Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. Let's start our day with Judge Vincent Collada in Lake County. He's about to do a sentencing.
001570, 25 CR 001571, 25 CR 001572, 25 CR 001573. Defendant is present in open court today with his counsel, William Watson. Your Honor, we're here today for sentencing in all 5 cases. The defendant was the last before Your Honor on November 25th of 2025, where he pled guilty by way of information to all 5 cases. In 1450, pled guilty to grand theft of a motor vehicle, felony of the 4th degree, and theft of felony of the 5th degree. In 1570, pled guilty to grand theft of a motor vehicle, felony of the 4th degree, and misuse of credit cards, felony of the 5th degree. The remaining 3 cases, 1571, 1572, and 1573, were all one count of grand theft of a motor vehicle, felonies of the 4th degree. At that time, a pre-sentence report, a psychological evaluation, and victim impact statements were ordered. The state's understanding that the report and evaluations were completed and provided to the court, and that approximately 4 victim impact statements were received by the court as well, and that all parties were prepared to go to sentencing at this time. Thank you.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I don't know what to say, Your Honor, in this case. This is kind of a first for me. This is a young man who I think still has his whole life ahead of him, and got himself into a world of trouble, and not only here in Lake County, but in other counties too. I know the court's well aware that he was already on probation, I believe out of Cuyahoga County, when he went on his little crime spree here in Lake County and got picked up. Has been sitting in our county jail for almost 3 months now, and I know that there's still pending charges, and I believe Cuyahoga County and I believe Portage County. So Mr. Hudson has certainly dug himself a very deep hole at a young age. I can say, Your Honor, ever since I met him, I think he's actually a good person, and I know that this doesn't, why he's before this court does not reflect that at all, and I know this court probably has no reason to believe that, but I've talked to him numerous times. He is very remorseful for what he did. He wants to try to make it right. He was cooperative with the police departments, various police departments, when they came and talked to him. He's told me since the beginning that he's done. He's through with doing what he's been doing. And the reason he did it, now, I know that there was a little bit of a difference of opinion in chambers on this, but Mr. Hudson told me that he was homeless at the time, and not that that's an excuse or to justify what he did, but he was homeless and he was out doing what he had to do, according to him.
It's not what he told probation.
I'm sorry?
It's not what he told probation.
Well, again, Your Honor, I know, that's why I specified that there's a difference there, but with respect to the court, Your Honor, I know Mr. Hudson's got a lot of time ahead of him with these 5 different cases. I know the court today can do a lot of different things when it comes to sentencing. I'm simply going to ask the court to just look at the fact that he's still a young man. He just turned, I believe, 22. He still has the potential to turn his life around and do a lot of good. He's expressed to me he wants to do that. I believe he wants to do that and will do that. I'm hoping the court will take these factors into consideration. I know in chambers I had asked the court to consider either a community control sanction or on a lower end sentence. And I normally wouldn't even ask for a community control sanction on a case like this, had it not be for his age and for the fact that he's cooperative. And again, at least with me, he's been very remorseful with his actions, and he does want to make a change, Your Honor. But if the court doesn't feel that that's appropriate, I'm just asking the court again to consider the fact that he is a young man. He still has his whole life ahead of him, and I just hope the court considers that. Thank you, Your Honor.
Mr. Hudson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
No, sir.
Mr. Watson, anything else?
Just that, Your Honor, I actually want to just quickly add, my client was actually going to say something, and then right after I came out of chambers, and I had told him the state's recommendation, he opted to say nothing, and I just wanted to let the court know that I think it's because he's given up. He's just throwing in the
You're
towel.
speculating here. But you can do whatever you want. You can say whatever you want, I guess.
I may be
I gave him a
speculating,
chance
Your
to
Honor,
speak.
but...
He's not speaking.
Okay, I know.
I'm
I
not
just-
going to consider the fact that, he was going to speak. He's not speaking.
Okay,
He doesn't
well-
have to speak. He has a right to. He doesn't have to, and I don't hold that against him if he doesn't want to say anything, but
Okay.
I'm not going to take into consideration that he was planning on speaking. I mean,
No, I was letting the court know, I think he's thrown in the towel, but that's all, Your Honor. Thank you.
cuts for the state of Ohio.
Thank you, Your Honor. Before I address the court, I would ask, Mr. Costello is here. He's from case 25 CR 1572. He would like to address the court.
Mr. Costello, you can just stand right where you're, state your full name, please, to the court reporter, and then spell your last name. I think we probably figured that out, but spell it anyway, and then say
Joseph Costello, Gatwick Costello, Costello.
Go ahead, take your time and say whatever you'd like me to know.
Can I address Mr. Hudson?
You can say whatever you'd like, yeah.
So, Mr. Hudson, I know you may or may not listen to what I have to say, but it's hard to be a man, and our decisions have brought us to where we are, and unfortunately your decisions have brought you here. I never expected to have my car stolen and for it to affect my life the way it did. But I look at that seal behind the judge that says, with God all things are possible, and I do pray that after this experience, after you go through whatever it is that the judge hands down, that you find a new path, man. That, even though you're young, like, you got the rest of your life ahead of you. Like, yes, it sounds like you may be in for a while. I'm not quite sure, but I do pray that, excuse me, that when this season of your life is over, you got family over here that sounds like they love you, and sounds like you got a young daughter who also loves you in your life. So I pray that, man, you go through this season of your life, and the next season of your life, you make better choices. I do believe in paying for what he's done. We all got to stand up and take what's coming to us, but I do pray that, man, you turn this around eventually. 22 years old is not the way to start this off.
Thank you, Mr. Costello, very much. Ms. Kutch for the state of Ohio.
Thank you, Your Honor. These cases encompass 5 different jurisdictions from August 2nd to October 1st of 2025. Have been affected 5 people with their cars being taken, an additional person with credit card being taken out of the car. So we have Wickliffe, Eastlake, Willoughby Hills, Willoughby, and Menor Police Department. It starts with Mr. Costello's car on August 2nd. That's the 1572 case. His car was recovered. Thankfully, it was not damaged. It needed to be aired out. Keys were no longer there. So insurance did cover a large portion. However, Mr. Costello did have to cover his deductible of $250. On August 31st, in Eastlake Police Department, Mr. Dolan's vehicle was taken. That car was recovered by Akron Police Department with no new damage. However, it had to be towed. There was a cell phone in the car, some other things that had to be dealt with. After insurance, Mr. Dolan had to pay $500 out of pocket. September 20th in Willoughby Hills, Mr. Boyd's vehicle was taken. It was recovered about a week later by Cleveland Police Department. His vehicle was totaled. It was recovered because there was an accident at an intersection where the defendant was driving the stolen truck. He left on foot after the accident, and a female was taken to the hospital. I don't have the details of some of that because it was in another jurisdiction, but that is the information I received. Mr. Boyd indicated to me that insurance totaled his car and that he had a deductible of $250.
Did you say that was September 20th?
The vehicle was taken, I believe, September 20th.
You have September 2nd. I don't know which one you transposed numbers.
That's 1571. Then September 29th, in Willoughby, Miss Bostick's vehicle was taken. That car was eventually recovered in Garfield Heights. Garfield Heights became aware of the vehicle in their community, I believe through Flock, that it was a stolen vehicle. They went to do a traffic stop. The defendant fled from the police, high-speed chase. He struck a pole that broke, took another pole down. They had to shut the street down to fix that. The car rolled. Thankfully, the defendant was not injured. He was the only one in the car. The police informed me that they were very concerned. If he had not hit the pole, he would have gone into a house that had an elderly female in it. Garfield Heights did arrest him at that point, and that case there's a warrant out in that case. And then October 1st, a car was taken from Menor.
So he bonded out, obviously, then on the September 20th one?
He was arrested October 3rd.
Oh, never mind. I got you. Right.
On October 1st is the Menor. The vehicle was stolen outside Ms. Carney's work. It was recovered that same day by Cleveland, thankfully without damage. In that case, her credit cards had actually been taken, and 4 credit cards were used for over $1,000 worth. She did get that back, but obviously the banks are out. Another case that was put into 1450 dealt with Anthony Tortorici. His car was not stolen, but while he was parked at Heinen's, the defendant went into his vehicle and took a credit card, went to Walgreens and spent just under $40 on a gift card. He was also reimbursed by his bank, but they are out that money. So this was a long, continuous occurrence in Lake County. We are aware that there were Cuyahoga County and Portage County issues as well, which I will get to. But just in the seriousness of this case, there was obviously taking people's property, damaging it, other people being injured or affected, and damage to property. So this was an extensive incident that was going approximately 2 months in Lake County alone. And all of these individuals were negatively affected, some more than others, but none of them deserve to have their vehicles taken. Defendant has been in the jail since October 3rd. However, he is serving a Willoughby Municipal Court sentence from Willoughby Hills Police Department, where there was a theft of, my recollection is, a bag that had electronics in it and things of that nature. So he has no credit in any of these cases based on that and the fact that some of them were secrets that he wasn't booked in until he came to this court. So we have the economic harm, some of the psychological harm from having your items taken or people being in your vehicle without permission. Some of the individuals had things in their cars that could identify where they live or where they work, which always adds a level of concern. I know of at least one individual who changed their locks at their home because their house keys were on there, and just concerns of work keys and if anything could happen to that. So there's a whole level that goes beyond having one item taken. In addition to that, the defendant does have a history of criminal convictions. He mentions in 2022 a breaking and entering. I don't know if that was confirmed. In 2024, he has a conviction for misdemeanor theft. In 2025, he has convictions for unauthorized use of a vehicle, misdemeanor of the 1st degree, which he currently has a warrant out for, grand theft of a motor vehicle, felony of the 5th degree, which he was on probation for, and then theft and misdemeanor of the 1st degree. He's put on probation in both of those cases, where they occurred in September, while most of these were going on. He has warrants for failure to appear from Portage County Municipal Court in Kent. He has a warrant for Orange Village for grand theft of a motor vehicle, which the state's understanding is another vehicle that was stolen outside of our county, I believe prior to some of these incidents that involved threats to the actual car owner. There's a warrant out of Garfield Heights Police Department for failing to comply, vandalism, and receiving stolen property, which goes to the vehicle that was totaled in $1450. And then it appears he missed an arraignment on a burglary, theft, and identity fraud case. He has had issues while he's been in the jail. There have been some serious violations based on the terminology of the jail. In October, an assault on an inmate. In November, an assault on an inmate, and also threats in November. He was on probation for at least 3 of these cases when they occurred, and was at least on bond on that case prior to putting on probation on the other 2. Prison is clearly consistent. The question is whether he is amenable. The court is concerned that there wouldn't be things that would help him at this point. He has indicated that he knew it was wrong, he knows it is wrong, he knows he should stop and not do it. He indicated that he knows to leave other people's stuff alone before I steal from the wrong person, which seems to imply more of a concern of if somebody is violent with him, then that he should not do it. He did have opportunities in his home. Obviously, the loss of a parent is always difficult, but it doesn't make it okay to steal from other people and create more issues in their lives as well. So we do feel the prison is consistent. He has 0 credit. We would ask for the restitution to be ordered in each case. And that we feel consecutive sentences would be appropriate based on the multiple courses of conduct, the multiple victims, being on probation or bond. And that would be the state's recommendation at this time.
Thank you. This court reviewed the pre-sentence report and investigation, psychological evaluation. I've read all the victim impact statements I received from all the cases. I've considered the facts and circumstances of the offenses, the nature of the offenses. I've considered everything that's been said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, the court notes that in each of these cases the victims suffered serious economic harm and psychological harm. Some of the victim impact statements detail what these folks are still experiencing, the stress that they're experiencing. It also talks about what they have to go through. Yeah, sure, they lost property that could be replaced perhaps, but the inconvenience, the time you have to spend to cancel all your credit cards, the time sitting on a phone, the time having to replace everything, it's hours and hours and hours. And these people shouldn't have to deal with all that. And they had to. So again, the economic harm as well as the psychological harm. No factors indicate that the offense is less serious. You know, his age or youth certainly doesn't change the impact his conduct had on the victims and on our community and society. It's not less of an impact because he's only 22. They still experienced and had to suffer what they suffered. That doesn't make it less serious. As for recidivism factors, the court notes the defendant does have a history of criminal convictions, even though he's only just turned 22. He's got multiple warrants out for him right now for similar type of conduct in other counties. He was on probation for 2 different cases at the time he committed the offense. Literally put on probation September 3rd, and he's committing an offense within a couple weeks later. Same type of stuff, multiple offenses. So he says he knows stealing is wrong, but gets put on probation for it and just continues doing it. Also, in regards to these offenses, while the conduct didn't occur in Lake County, these stolen cars he's driving, he's ultimately driving them in high-speed chases with police officers. He's causing damage to people. He's causing damage to property. Fleeing from police and trying to get away with it. I had noted the same thing the prosecutor noted when he was talking about what he has learned. His comment is, I know now to leave other people's stuff alone before I steal from the wrong person. There's no genuine remorse. No factors indicate recidivism is less likely. Under 2913B1, the court notes that the defendant was on probation to Cuyahoga County in 2 cases. He committed the offenses in 1450, 1570, and 1571. Prison is certainly consistent with the purposes and principles of sentencing. And when you look at the nature of the conduct involved here, I certainly take issue with the characterization of he was on this little crime spree. I mean, he's a walking, talking, breathing crime spree that just still continues on. Even after he gets caught and arrested and put on probation, he just gets right back up on the horse and continues doing the same stuff. And it's not amenable to community control sanctions, and quite frankly, the spree that he went on and the conduct he engaged in over and over and over and over and over deserves prison terms. Therefore, it will be the sentence of this court that in case 25 CR 1450, defendant serve a term in prison on count 1, 24 months. On count 2 of 11 months, I'll run those 2 counts concurrent with each other.
Your Honor, what on count 1?
24 months on count 1.
24?
Oh, wait, I'm sorry. It's an F4. 18 months. On count 1. 11 months on let me change this real quick. I'm sorry. I'm starting over. We do 17 months on count 1, 11 months on count 2. Those will be concurrent with each other. It's going to be restitution to Mr. Bostic in the amount of $1,350 and to Fifth Third Bank in the amount of $38.95. Case 25 CR 1570. The sentence of the court, then count 1. Going to serve a term in prison of 17 months. And count 2, 11 months. I'll run those 2 terms concurrent with each other, but consecutive to the prison term imposed in 25 CR 1450. Defendant's ordered to pay restitution to Chase Bank in the amount of $212, the Bank of America in the amount of $319.95, Capital One in the amount of $415.90, and American Express in the amount of $346.90. Case 25 CR 1571 is the sentence of the court. Defendant serve a term in prison of 17 months. They'll be concurrent to the terms imposed in the first 2 cases, 1450 and 1570. Restitution in this case to Mr. Boyd in the amount of $250. Case 25 CR 1572 is the sentence of the court. Defendant serve a term in prison of 17 months. They'll be concurrent to the previously imposed terms, prison terms. Restitution to Mr. Costello in the amount of $250. In case 25 CR 1573, defendant shall serve a term in prison of 17 months to be served concurrent with the previously imposed terms. Restitution to Mr. Dolan in the amount of $500. There's no credit for any time served in any of these cases, as the defendant was serving a jail sentence on an unrelated case at the same time he was in jail in this case, in any of these cases. So it's a total of 34 months in prison. Defendant's ordered to pay all costs incurred in all these actions. Need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months. For each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Court further finds consecutive service is necessary to protect the public from future crime or to punish the offender. The consecutive sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And he committed one or more of the multiple offenses while he was on community control sanctions. And that at least 2 of these multiple offenses were committed as a part of 1 or more courses of conduct, and the harm caused by 2 or more of these multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as a part of any of the courses of conduct adequately reflects the seriousness of his conduct. These are 5 separate thefts here. They should each be punished separately. I've only run 2 of them consecutive. But I believe that's warranted. I think that covers everything. Ms. Cutts, is there anything else I need to address or that I've omitted?
No, Your Honor, thank you.
Swanson?
Nothing from the defense, Your Honor.
All rise. All right, good morning once again, everybody. Excuse me. Happy Monday. Welcome to the Courtroom Files Live. I haven't seen you guys since before Christmas, so I hope you all had a good Christmas with friends and family. I hope Santa got you everything that you wanted and more. Just a couple of notes. So it is an incredibly quiet morning out there in Courtlandia, more than I thought it would be. We'll see how things develop. The goal is to do 3 hours today, but we'll see what the day brings us. And as well, I had previously announced that we're going to start a 4th hour on January 5th, so next Monday. I'm actually going to push that back 1 more week. We're going to start that January 12th because next week has suddenly turned into healthcare week here at the TCF bunker, and I want to start when I'm able to give it my full focus. So we're going to delay that by 1 week, and we'll keep the schedule that we've been on through next week. Let's go to Miami-Dade. We'll spend a little time with Mindy Glazer this morning.
Is he here?
Mr. Ernest Diaz? Yes, he's
Yes, he's
here,
here.
Your Honor.
Okay,
Just a
so-
second.
This happened maybe today.
Okay.
Good morning, Mr. Diaz.
In Spanish, please.
Buenos días,
Sir,
señor Díaz.
You were arrested for aggravated battery. I will appoint the public defender's office for you.
Señor, usted fue arrestado por agresión con agravante. Le voy a nombrar la oficina de los abogados de oficio para que lo represente.
There is probable cause for the charge.
Existe motivo fundado para esta acusación.
So you are ordered to stay away from Nelson Narir, the alleged victim.
A usted se le ordena mantenerse alejado de Nelson Narriel, la supuesta víctima.
No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener contacto con la víctima ni directa ni indirectamente, ni en persona, ni por escrito, ni por teléfono, ni por medio de terceras personas.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Y tiene que mantenerse alejado de la víctima al menos 500 pies de su lugar de estudio, vivienda o trabajo en todo momento.
You understand? And also you can only return to the victim's residence one time only within 48 hours of your release from jail.
Además, únicamente puede regresar a la casa de la víctima una única vez dentro de las siguientes 48 horas de que salga en libertad,
to retrieve your personal, you must go with a police officer so that you can retrieve your personal belongings.
y tiene que ir acompañado de un oficial de policía para que usted pueda retirar sus artículos personales.
And if you go without the police or if you stay there, you will be arrested.
Si usted va sin la policía o si se queda ahí, va a ser arrestado.
Also, you have an immigration hold.
También tiene una retención de migración.
There's probably cause for aggravated battery state. What do you want? 7,500? He
Yes.
did had a 30-year prison sentence for murder, so I think that would be probably a wise move, even though he's 81 years old, to set the standard bond of $7,500.
Ok, señor, tiene una fianza de $7,500. Aparentemente sus antecedentes, usted tiene una condena de 30 años por intento de homicidio. Así es que a pesar de que tiene 81 años, esta es la fianza adecuada.
$7,500 bond. Good day, sir.
Tiene una fianza de $7,500.
Your Honor, the next person on the calendar session, he refused court.
Okay, let's, the Derek session, give me 1 second.
No problem.
Give me 1 second. Never did one of these, do probation ones. All right, next, I'm sorry, the Derek session refused, you said?
Yes,
You want to waive his presence? It's an.
Yes, we can wait.
Oh, he's right, Mr. Campbell. That's junior, not senior. So there's probable cause for battery by a detainee on another detainee. Bond is $2,500. Next up is George Scott.
he's in JMH, Your Honor.
He what?
Ward D.
Ward D.
Thank you. Does anybody review for PC or did I? No,
Yeah, I think last week.
Yeah, he's been in custody since the 22nd of
And the
December.
public defender's office has been appointed?
If not, we should. It just should be simple possession. If he was here, he would qualify.
Yeah,
for
they
that.
PC. All right,
Your Honor, Ward D's on the Zoom.
they are?
I think so.
Is the hospital here? Can you let us know who you are? There we are. See ya. Miss Eth, did your Zoom screen change? Mine's all dark now.
No.
I just promoted the hospital. I don't know if they're there. Hello,
Hello,
what is your name, sir?
George Scott.
Hi, Mr. Scott. You got arrested for possession of cocaine within 1,000 feet of a church or convenience store. There's probable cause for possession of cocaine.
Yes,
So
ma'am.
public defender's office is appointed for you. He's been, can I just give, do we have a date for him yet? We can just borrow arms to get out of jail.
Let's see. Hold on.
It's F 25-27314. January 21st? January, next month. You have to be in court on January 21st at 9 a.m. That's in 2026. Courtroom, what's the judge? Courtroom 48. Which Hirsch is that? Richard? Richard Hirsch. So can somebody at corrections write down January 21st at 9 a.m. for him?
Yes.
Okay, thank you. At 9 a.m., it's courtroom before 8. You got to come to court. I'm going to release you on your own recognizance so that way you can just get your medical care and just keep all future court dates. There's probably cause for third-degree felony possession of cocaine. All right?
Thank you very much, Your
And
Honor.
you feel better.
Corrections. Could you write down the public defender's number for him to, I can give it to
Yes,
you. Okay, it's 305.
I have it.
Oh, you have it? Okay, perfect.
All right, have a nice
you.
day. Thank you, corrections.
Thank you very much.
Ward D, are you?
Michael, thank you for gifting membership. Very much appreciate that.
All right.
Hospital,
Tomorrow?
Yeah.
you can't do it today?
I can't do it today. He's
And I'll
in
see you
another,
tomorrow.
another section.
No worries, thank you. Wayne Lane is next.
Yeah, Ward D, Your Honor.
Is he at the hospital?
Yes, he's Ward D.
Let me review for probable cause.
Count one should be a third-degree felony.
Okay. Right, so count one, there's 1 minute.
47.
Did I miss it?
No, I'm just reading
Okay.
his review of DC where it says car was stolen.
What is it? It's a Gucci?
I got it.
Oh, my.
So count one probable cause for grand theft of third degree
I don't know
felony.
why I said, sorry.
Corrections, your volume's on. Your microphone.
Thank you.
All right, count two, there's probable cause as well. What was it, Ward D? Reset tomorrow. Reset this afternoon, excuse me. Next case, Anthony Brown, page 13.
Your Honor, Mr. Brown, he refused.
Reset. Where's
No,
the
Mr. Brown is here.
Oh,
This is
that's
the added
right.
charge.
Added charge. Hi. Good morning, Mr. Brown. You were arrested for a case from September 11th of 2023. The charge is aggravated battery on a pregnant victim. I will appoint the public defender's office for you. So, sir, are you currently still together with the victim, Yesenia Valadares? Do you, it's domestic. Is he still together with her or no? The former girlfriend?
Are you with?
No. Thank you.
Yes.
So there's probable cause for the charge. He slapped the victim on her face and also struck her on her legs. Pulled her out of the vehicle. Fled the scene. All right. You are ordered to stay away from the alleged victim, Yesenia Luisa Valadares. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, her home and school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs, and do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, sir? I can't hear you.
You understand?
Yes, ma'am.
Do you see your children that you have with her?
Yes.
Third-party contact is permitted for exchange of the children for time sharing, okay? You see the children?
Yes, I can see him all the time.
All right, so you can go through a third party. That's why I asked you if you're still with her. You didn't.
No, I'm not with him. I had no dinner with her in
Say it again?
I had no dinner with her in 2 years.
I don't know what you said.
But he's been in custody, I think, Judge, for a while.
Oh, okay.
I have no dinners.
Got it.
2 years ago, that was it.
I'm sorry, it's hard to hear. The acoustics are bad.
Because I'm trying to figure out.
It's a delayed arrest. It's from 2022.
2 years
right?
old.
Yeah, because I
2023.
and I'm nowhere around.
State, what do you want for a bond? $2,500
That's fine.
bond.
Okay.
All right, next case is Nelson Perez.
Your Honor, these are added charges.
Thank you.
While we wait for the next contestant to come up, just a note for channel members, the pre-show will be making a triumphant return in January. I haven't decided yet if it's going to start on the 5th or the 12th, but it will start back up. You need to be a channel member to access the pre-show, though, so if you are out there and you are not a channel member, please consider becoming one. A whopping $2.99 a month. Not a lot. It goes a long way to support the channel, and you get extra content, plus early access to everything we post.
Okay, so where is Nelson Perez? Coming in the long way?
No, Your Honor, Nelson Perez refused court. These are added charges.
Thank you. It's behind it? I don't see one. Hiding. Okay, he has two cases now. Do you want to waive his presence? Fingers.
Yes, I'll wait.
So do you want to give Ms. Hill the name of the victim on F-25-27603?
Is the public defender requesting it?
Yes, please.
Okay, it's Sherman Howerton.
So on both cases, are you okay waiving presence?
Yes, Your Honor, we can waive on both, and if I can get the victim's name on the other one too.
So what's the case number?
F-25-27623.
1 second.
So on F-25-2760, I'm sorry, 27603, there's probable cause for the charge. The bond is $2,500.
In the other case, the victim is Craig Gilbert. There's multiple probable cause on the other case as well, $500 bond. Okay, next, Frank Botella, page 14.
Yes, Your Honor, he refused, he's been refusing since the 24th.
And they would decide now to have it 5 days? Oh, my finger.
They were waiting.
John, he's also known as John Doe. So you want me to appoint the public defender's office, waive his presence?
Yes, Your Honor.
They were waiting on you, Judge.
They're waiting for me. That's nice. Okay, for Mr. Botella, I will appoint the public defender's office, waive presence on F-25-27501, first probable cause for retail theft. That bond is $2,500.
Yeah, because. Yeah, because he came in as a
Corrections, your
John Doe.
microphone's on.
Yes, because he came in as a John Doe.
So do you want me to see John Doe?
No.
Okay. Then the next case, F-25-27556, retail theft from December 13th. There's probable cause for the charge. $2,500 bond. And appointing public defender's office, waiving his presence. And there's F-25.
All right, we'll keep an eye on Judge Glazer, but let's go to Michigan. Judge Middleton just logged on a little bit ago. Let's see what he's got going on.
This is file 252085. SM, People versus Tricia Marie Tepfer. That's you, ma'am?
Yes, yes, sir.
You were charged with domestic violence second offense. The matter as charged was punishable by up to a year in jail, fine of up to $1,000. I also lost my odd base. Now, the matter was reduced for a plea to domestic violence first offense. There was a bond violation in the pendency of this case, and you did 8 days in jail for that. The matter did result in a plea, and the matter was set for sentencing today. Trying to get my case open here.
Your Honor, if I may just ask the court, both Mr. George and myself have a record in our files that it was a domestic violence second offense plea.
Well, let's take a look, because I haven't opened it up yet. I was going from memory. On December 8th, which was the first Friday of the month, I think in December. It was a Monday morning. She pled to domestic violence second by no contest. I gave her 8 days jail credit, 8 days for the bond violation, let her out and set the matter for sentencing on domestic violence second. I allowed the reestablishment of the $400 bond, indicated she could be released pending sentence. I got the police report and let an opportunity for additional victim input. She did 8 days for the bond violation, and I believe she did 4 days at the front end. She was arrested on the 10th and she bonded on the 14th. So I think there's a total of 12 days credit. All right, with that being said, Mr. George, what would you like me to know?
Thank you, Your Honor. And just kind of adding on to that, just to make sure, because I believe Ms. Canfield was out when we entered the plea, but I believe that the communication that we had was she entered a plea to the domestic violence second. There was a recommendation of time served with probation.
That's what my notes reflect.
And I think we did get an update from Tiffany Howe last week that my client's enrolled in pretrial services and she continues to update and communicate with the office. I know the court can see her this morning and she looks well. I think she's in a good place. Your Honor, at its core, I believe that this is a tumultuous relationship that is probably on thin ice. I know my client has to make a decision how to move forward with that, but I believe that a supervision would be beneficial in this case. No matter what, there have been multiple issues between these parties. I'm not saying they're all my client, but there's got to be a better way to handle life stressors than to get into some type of altercation and end up with one person being in custody. So I think that there's programming that would be available probably on the anger management side that would be beneficial to my client. It would also continue this court supervision to make sure that she's doing what she needs to do, that there aren't any further issues. I would defer to the court on how appropriate the no contact order is at this time. This was the marital home. My client does continue to have items there. So there's going to be, if there is some movement on, some type of dissolution of this marriage, my client's going to have to be able to get into that home and there have to be arrangements that would be made, but we would defer to the court on that. Thank you.
Well, that is an issue, and it always is. They're married and they've been married for 10 years. And this set of circumstances prohibits her from going to her own house. And as far as I could tell, no one has actually filed for a divorce or a claim for exclusive possession of the home. And so that is an issue that we're gonna need to address. Ms. Canfield, what's your thought here?
Your Honor, I know Ms. Ackerman has spoken with Randy Tupfer, who has authorized her to make a statement on his behalf. So I would ask that the court allow that. With respect to the underlying offer, it is accurate. It was a recommendation of 24 months of probation with domestic violence counseling, which I think is appropriate. I might have asked for some additional jail time because of the defendant's record. I do see convictions from 2013, 2014, and then January of this year, which is concerning to me. I think that recommendation came from Ms. Stoll with the underlying circumstance of this particular incident, not having severe injuries, things of that nature. The repetitive conduct obviously is what's leading to the downfall of the marriage and the divorce that's going to be pending or is pending at this time. But I do think that the counseling and supervision would be helpful and appropriate to get her through the divorce pendency, hopefully without any more incidents and coming before this court again. I know that I do have concerns for Mr. Tupfer's safety. So I'll let Ms. Ackerman speak to his wishes with respect to that. I myself personally would recommend that there be some sort of no contact, but for a pickup of personal property and or communications regarding the divorce, but I believe he does wish to have communication and contact with her.
Ms. Ackerman, good morning. Would you state your name for the record, please?
Kendra Ackerman.
All right, and you've got a message from Mr. Tepfer?
Yes, he called this morning. He's unable to attend the sentencing today because he had to work. It is his wish that the bond be modified to allow him and Tricia to have contact with one another, to be able to speak, to be able to spend time with each other, as well as her continuing with counseling. He also asks that she receive no additional jail time.
All right, thank you. Ms. Tepfer, and I have a message for Randy Tepfer. You got unpaid traffic tickets. Please come in and pay them. I'm aware of you and Randy's relationship. Mr. George is right. You look good today. Nobody looks too good after sitting in jail for 8 days, which is how I saw you the last time. You're still staying with your father in Burr Oak?
Yes.
This has been a tumultuous relationship. On the day that you got arrested back in October, it was near your 10th anniversary. You had some wedding stuff out on the table and Randy was angry and dumped all the stuff off the table. He claims you just leave for days at a time. He doesn't know where you are or what you're doing or who you're with. You have a different view of it. Anyway, he dumped all the stuff off the table. You threw what was listed as a mailbox, hit him in the middle of the back. The police came and they took you to jail. And you've been prohibited from going to your house essentially since then, although you went back anyway and ended up doing 8 days in jail for that. So as I indicated, you did 4 days at the front end and 8 days. Have either of you started a divorce?
Yes, I did file.
All right. Do you have an attorney?
No, sir. We don't have anything to fight over really.
Okay.
For as far as the mortgage goes, I'm on everything and I'm on the deed. And the only thing I have to do for the house, if we decide to divorce, is just get a divorce and then I'm off there. And I have to come up here to do the deed thing. That's it. If we do go through with it all.
Well, the mortgage and the deed are two different things. You can sign your interest.
I'm not on that. I'm not on the loan. I'm on the mortgage.
All right, well,
the bank.
all right, so let's say you both co-signed to buy this house for $1 million. And then you sign your interest in the house over to him, so he owns the house, but you made an agreement with the bank to pay on the loan. So simply signing your interest off in the house may not remove your interest on the loan unless the bank removes you.
Yeah, I'm not on the loan. That's the one thing.
All right, you're not on the loan. Okay, so you're willing to just give the house to him.
Correct, yes.
As Mr. George said, you've done a good job on pretrial services. I think 8 days in jail got your attention here.
Oh, yeah.
But if it's this bad for everybody, you each need to go in a different direction. So I'm going to follow what everybody asked. I'm going to do a 12-month probation for which you could be discharged at the end of 6 months. I'm ordering 24 days in jail credit 14. Of the 24 days, 10 are deferred. So you're not going to do any additional jail time if you do what I ask you to do. Well, I got some jail home over your head. The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, a $150 attorney fee, and a $480 probation oversight fee. You're not eligible for a deferral, so I'm not going to send you to the Women's Anger Management. I think you already did it once. Randy's had some issues in his past, but I didn't see that he was ever charged with an assaultive offense. I know you contend there's been back and forth, but the person before me here is you. The fine and cost from the state is $125 plus $150 for your attorney fee and $480 for your probation oversight fee, which is $755. That's due in 1 year. And if you do it in 6 months, take $240 off of it. You are to engage in no assaultive or threatening behavior, no drugs, and no alcohol. Test as directed, including marijuana. Do you abstain from the use of any alcohol or any controlled substance, including marijuana, which is lawful for adults to use for recreational purposes, but when we have people on probation, we do a big timeout. He wishes to allow contact, and I guess you need to have contact to resolve your divorce. I am going to indicate you may not reside at the Vicky Drive address.
Well, he's not, I mean, like stay there, or
You can visit there.
like, because when he's gone, I usually go in, and that's why I get to see the cat, my therapy
All
cat.
right, you talked about the cat. You can't move in there without order of the court. But you can have contact, you can go there.
Okay.
Now, I don't know, stranger things have happened. Maybe you'll reconcile and live happily ever after. I don't know. But going to jail isn't fun for anybody. Have you found employment?
Currently, no. I do have some medical things going on in my hand. For instance, I did not get the surgery that I was supposed to get. So now they have to re-break it and it'll be a bigger thing. So my hands are kind of not usable at the time. I can do little jobs. I've been helping clean side jobs, but nothing as far as getting a job yet.
Well, you're in a stable housing situation with your dad. And thank you for that. Who was your probation officer last time?
Autumn?
All right, we'll try it again. You got to keep it together. No assault or threatening behavior, no drugs or no alcohol. You can't move back into that residence unless I allow it.
Okay.
But you can certainly go out to lunch, you can go to breakfast, you can go to the movies, you can go over there and have dinner. But I want you to move your stuff in there. And if you do get divorced, well, hopefully it can be as amicable as possible. But you're free to go.
Thank you, Your Honor.
Thank you.
Good morning once again, everybody. It's the court, not a courtroom files. There's like 24 courtroom files on YouTube now. So look for the TCF logo now that I bring that up, because everybody is trying to copy us here, often duplicated or imitated rather, but never duplicated. I'm going to shut up because I don't even know what I'm talking about. Anyways, it's Monday, which means I'm stumbling over my words because that's what we do here. Let's do this. Let's change it up. Let's go to Amarillo, Texas, and see what's going on with their jail arraignment docket. This is Judge Ratliff.
You came in and entered a plea on a no liability insurance, and you paid about half of it, and then you stopped. The last payment we got was $6,300. Why'd you stop and then not come back and tell me why you quit paying?
What had happened was I had my car at the time, and like around that time my car was overheating and stuff, so I was sitting in the shop, and it ended up it being too much to fix, and and so I had to let the bank take it, and also at the same time I was right around draw. This is like 5 months ago, and I started working at the
June. Your last payment was June 3rd.
June 3rd. Oh yeah. So end of that month, I'm like, when I didn't have my car, I had kind of forgot about it, for a week or something. Oh crap! I have those because they were saying I can't remember if I got any notification or anything in the mail, but something or I said something about Randall County. That reminds me of it was something random that was not for me, but it was in my email, and it said, I was like, oh crap, I have those. I thought I was almost done. Like I had like one.
We're halfway done, and we sent you a pending warrant letter to the address that you gave my clerk, and we sent you a notice for a hearing at that same address. Were you not getting your mail?
Well, I may not have gotten that one, but I felt like it might have been a TPS warning, but like I didn't have my card, and so I was telling myself, man, I need to call them and tell them that I didn't have my card and make a payment arrangement so I don't get it, and so I just never did, and
Right. So it's been at warrant since August 4th. So as of today, well, as of yesterday, you had $215. I will give you $150 jail credit. So that means today, to get out of jail, you need to have somebody come and pay $65. Do you think somebody can pay that for you?
Yes, I do, because like so now, and the reason I came to jail last night was because I was but I didn't have a place to stay last night because my grandma, she wanted me to go. So she wanted me to go with the first of the year, have a place, to go with my friends and stay with them. But lately, I've been staying with my
Made it
grandma.
easy for your grandmother to kick you out, right?
Well, of course, yes. So and I'm like, I'll let her, I'll leave calm. I'm like, all right, and so I'll go to my friend's house, and then and I stayed in my friend's house a couple nights ago, and so about a little over a week ago, like LaBella's, I wasn't getting enough hours, so I was gonna get a new job, and I'd already gone through like 3 months before that, put my 2 weeks in, and I got a new job.
Where do you work?
Oh, I was working at LaBella's, and I did work help my friends, you know, uh, they live right by LaBella's, a couple of my buddies that I was working at LaBella's with, and so I was helping them
Where
out.
do you work?
LaBella's on 6th Street.
What is that?
LaBella's, it's a pizza.
Oh, okay.
Yeah,
Okay.
yeah. The main one was like
Do you get food stamps or federal housing help?
no, because like I said, I've had the job, but I've been staying with my grandma, and the past couple of days, so 2 days I stayed with my friend Jazz, and he was the manager at LaBella's, and so of course I was helping him out because it was only him and Aaron, and but only a little bit. I'm like, man, I'm not getting paid for this, so but he's my friend, so I'm helping him.
I'm gonna find you didn't make a good faith effort, because when you know that you owe it, it's, even though it's not very much, you gotta come talk to me if you're not paying it.
Oh, yes, ma'am.
And so it's either pay $65 today or you'll get out sometime tomorrow.
Okay, yeah, and like I said, I have a cup, like, I have some money that I can pay. I came in with some, like $100 on my cash, and so I can pay it if I.
Okay, well, it might be that you don't have access to that cash as you came in, so you might have to call somebody to come pay it, then you pay them back.
Okay, and then so we're so they showed me the money that I have in my book full last night.
They're like a bank there, so they take it and then you don't get it automatically back. But you could talk to your pot officer about that. If you pay $65 today, you'll get out today. If not, or you or somebody else doesn't pay it, then you'll get out sometime tomorrow morning. Any questions?
Okay, so and if I'm not able to get the money out of they put on my books, and I'm not able to get out.
Your pot officer will talk to you about that. Most likely you have to call somebody and have them come pay it, then you can arrange to pay them back.
Okay, so I was gonna ask if I'm not able to get a hold of somebody and call someone today, and which is fine. I stay till tomorrow and pay it when I get out and get the money out, but.
Right. But you won't know anything if you sit it out.
Oh, okay. I won't owe the $65. Oh,
Well,
okay.
if you sit it out, if you stay there till tomorrow about 8 in the morning, you'll be done.
Oh, okay. Yeah.
Okay. Okay. You can return to your pod.
Okay, thank you.
Jesse Espinoza.
Yes, ma'am.
Okay, old ticket. Well, not that old. October 13th, 2025. Fine range is $1 to $200. It's called expired driver's license. On that charge, do you want to plead not guilty because you want to hire an attorney or have a trial? Or show me your driver's license.
Not guilty.
Say it again.
Not guilty.
Okay, so are you gonna want to set it for trial, or are you just gonna bring me a valid driver's license?
I could go get my license and bring you a license.
You're a little too late for that, because this was from October 13th. You let it go to warrant. Not guilty means you want to have a trial where it's the state's burden to prove that your license was expired. Guilty or no contest means your time served. Which way do you want to go?
No contest.
Okay, on your no contest plea, finding court costs is $260. On that, your time served. If you get out of jail and you wish that you had changed your mind and pled not guilty and requested a trial, 10 days from today is January 8th. That'd be the deadline to come tell me you've changed your mind. Any questions?
No, ma'am.
Okay, thank you. You may return to your pod. Mr. Grasso?
Yes, ma'am.
Come on up. I know it's slow moving, right? And come up a little.
Sit down, ma'am.
Sure, sit in that front chair. Now tell me why you have to sit down.
My hip is broken.
Your hip is broken?
No, now.
Right there's perfect.
I hip replacement in 1999.
When did you have a hip replacement?
24 years ago. 1999.
And it's still a bum hip?
No, I had a hip replacement then, and it lasted good. They said it'll last for 15 years, supposed to last for 15 years or when you make it. So it's been 24 years, so I've done pretty good.
So you're kind of due for a new one?
It's going out right now. It's right in the middle of it's going out totally. It's almost where I'm gonna fall down one time and I can't move. I can't back up again on that leg.
So back in September on Canyon Drive, do you remember getting a drug paraphernalia possession regarding a pipe ticket?
Yes, ma'am.
On that charge, do you want to plead not guilty, bond out to come set it for a trial?
So, all right, it was the original, what they were there for and what they charged me with is possession. But actually, he didn't know I had possession until I told him, and I fully cooperated, and he went to cuff me. And I said, I fully cooperated, and you're cuffing me. And so he uncuffed me, And then he decided he's writing me up, so he wrote, as they said, it's like a citation.
You didn't get arrested on September 29th? You didn't get arrested, or you did?
On that sleeping in the parking lot.
Well, on that drug paraphernalia possession that you got on September 29th, did you get arrested?
No.
Okay, you just got cuffed and then questioned, right?
And I was told, yes, ma'am. So somebody told me, referring to some helper, said if there's no money mentioned on the paper, and there was none. And he said that it's just a citation and it won't cost anything. But
So the question I have is, do you want to plead, do you want to plead not guilty, get out of jail with a bond with a promise to appear on that drug paraphernalia possession from September 29th?
I already failed that, right?
Say that again?
I already failed that, right?
What do you mean failed it?
I didn't appear on the.
Right, that's why you're talking to me today, because you have some choices. Do you want to get out of jail with a bond with a promise to appear to set it for trial? Or do you want to plead guilty or no contest?
No contest, ma'am.
Okay, on your no contest plea, you waive a right to a trial. Finding court cost is $616. Now, I'm going to give you $300 jail credit. You're not time served.
Okay.
Now, the reason the police came into contact with you yesterday is because you were needing to go to the pavilion, is what I understood. Do you still need to talk to somebody?
I was gonna give up totally because I can't control my bowels. So I was gonna give up. But I know you're not supposed to give up, I don't want to give up. But I just need some kind of nursing home care.
So let me ask, hey, officers, is anybody from TPC there today?
I haven't seen anybody, Judge.
So, Mr. Grasso, there's an order I can enter that tells the mental health authorities that they've got to come see you there at the jail. Do you want to stay there at the jail another couple of days and wait to see if a social worker will come by and see if they can't help you with some placement somewhere?
Yes. Yes.
No, guys in the back, I don't know who I heard yes, don't help them. Do you want to, or do you want to get out of jail and they are going to have a hard time tracking you down? Where do you usually stay?
I don't want to leave myself in total. I don't want to get lost. So.
Okay.
Yes, I want to remain in jail for the 2 days.
Okay, so that's called a voluntary
If
remand.
I owe anything here, I don't cross myself with anybody.
Okay, so I'm going to enter that order. I'm going to enter an order that requires the mental health authorities to send a caseworker to come see you.
Okay, thank
They can find a place for you somewhere, they will. But if they can't find a place for you after, let's see, 2 days, it'll be tomorrow, which is Tuesday.
Sure they will?
You would get out on Wednesday. I can only hold you there 2 more days, okay? And the hope is a caseworker will come.
It will count for.
Your paying of your fine, right? Okay, so you can, if you can get up, you're gonna stand and walk to the back and sign a form called, he may bring it up to you, a voluntary remand. And then I'm gonna see if I can't get a caseworker to come see you there today or tomorrow, okay?
Okay.
And you're sitting the rest of your ticket out, so there's no orders for you to appear. You have any questions?
So my time, they'll let me go when they let me go, right?
Right. Once you've sat it out, you'll get out, and you'll either get out because the mental health people have a place for you to go, or you're going to just get out because I can't hold you there anymore. Okay.
Thank you. Thank you, Your Honor.
Okay. Thank you. And he has that form for you to sign.
All right. Thank you.
Well, he's in between. Well, she rather is in between contestants. Thank you to Michael and to England SJ for helping me out as we troubleshoot here. We've changed how the show goes out from the bunker, and the reason that we did so is we're going to have a surprise or two for the coming 4th hour in 2 weeks that needed us to be able to send the show out differently. But we knew there would be bugs. That's why we did it early, and audio was a little low. I think we've got it better now. I had to adjust it in like 52 different places, but hopefully we got it sorted. Let's get back to Judge.
The food bank now, and with the holidays and everything coming up, it had slipped my mind, but I'm like 10 blocks away from the food bank on Ross now, where I could actually get to it. But
why didn't you come back and tell me that that was the situation?
yeah, well, I couldn't be driving. It was just hard for me to get around, Judge, and I apologize.
But you were driving yesterday.
Yes, ma'am. I had to go pick up my kid. That's the only reason I was driving.
So you still owe $11.98.
Yes, ma'am.
You have a job?
I'm self-employed, ma'am. I go do yards or auto detailing or paint houses, just whatever comes up.
Why did you let him go back to warrant? Why didn't you come tell me?
I know, I just didn't.
Do you want to sit them out? Do you want to sit them out so they're done?
No, I'm actually down the street by the food bank. I could actually get to the food bank a lot easier now. I'm like 10 blocks away from the food bank where I moved to my new address. I live like right behind Sam's. Nice little neighborhood.
So I'm gonna look. How'd you get a new place?
It's through HUD. It's a HUD deal, and the guy that I actually work for, he owns that house in the area, so he got it HUD approved, and then that's how I moved into there.
And so do you have like a promise to work on the house or something too?
Yes, ma'am. Yeah, it's a verbal agreement between me and the owner of Volvo Motors. That's who owns the house. So
when I sent all my notices, because now I remember talking to you, I didn't know where Paradise Street was.
yes, ma'am. That was over off of 24th and Grand, back on the north side, and they quit giving us all our mail and stuff from over there. So, but we got a whole trailer stolen full of all of our stuff before we actually got moved. So they took like a whole trailer of all of our furniture and kids' birth certificates and all kinds of stuff.
How many kids do you have?
Two kids,
How old are they?
15 and 13, or 16 and 13.
All right. I'm gonna find that I want you released to appear tomorrow.
Yes, ma'am.
Be here tomorrow. Can somebody bring you?
Yes, sir. I'll be there. If I have to walk over there, I'll be there.
Well, it's a long way and it's gonna be cold. So get somebody to bring you. Tomorrow you can come at 10:30 for an 11 o'clock hearing, or you can be here at 1:30 for a 2 o'clock hearing, no later than that, or they go back to capious warrant. You and I'll be talking about 1198, okay?
Yes, ma'am. I'll see you in the morning.
Okay, I'll see you tomorrow.
No, thank you.
Alan Williams. Okay, so this charge is different than everybody else's because it has a lot of extra consequences. So the charge is called assault by contact family member. The fine range is $1 to $500. Court costs are $81. The extra consequences are as follows. One, if you get a conviction for it, you get a conviction if you're found guilty at a trial, or if you plead guilty or even plead no contest, you get a conviction. A conviction means that the state keeps a registry of your fingerprints in a state registry for these kinds of charges. Future charges can be filed as a higher charge with proof of a prior conviction. Also, it hurts background checks for jobs, and pursuant to federal law, you can't own or possess firearms or ammunition. If you do have firearms or ammunition after you get a conviction for this charge, you'd be seeing a federal judge. You wouldn't be seeing me. It's a federal violation. Also, it hurts rights to child custody. So let's talk about just the case itself. It's assault by contact family member regarding Audrey Burgett by throwing a drink at her. On that charge, do you want to plead not guilty, bond out to start the process of having a trial? or getting time to hire an attorney. What do you think you need to do?
I just need to get back to work as quick as I can, but.
You work here in Amarillo?
Yes,
Okay, and do you live at the same location as Aubrey Burgett?
yes, I guess, and I've talked to her since I've been in here, we're good,
Well, if you bond out, I'm gonna say you've gotta have distance. You can't be at that location where she lives. You have to go be someplace else because it's a pending case. And obviously something bad happened yesterday, right? And so that's fine. You can have a different place to live and work through the process of appearing and requesting a trial and working through getting ready for a trial if there will be one. Or you can plead guilty or no contest, finding court costs total $485. I do give you $300 jail credit, but you remember I just told you all those consequences of a conviction for assault by contact family member, and it's really serious. Even a Class C is serious.
I'm not worried about nothing happening again.
Well, do you want to plead not guilty and bond out, but the bond's gonna say you can't have contact with her until it's resolved, the charge is resolved?
I'll just plead guilty.
Okay, you understand all those consequences I just gave you to a guilty plea to assault by contact family member.
Well, be that way, Judge. Just cut your feed right in the middle of a conversation. Let's go back to Lake County, Ohio. There is a new contestant in front of Judge Coladas. Let's give that a go.
Similine?
Good morning, Your Honor. We are hearing case 25 CR 1091, State of Ohio versus Joshua L. Smith. Present in court is a defendant who's accompanied by his attorney, Mr. Chad Mulkey. We were previously here on November 17th, 2025. At that time, the defendant withdrew his previously entered plea of not guilty and entered a plea of guilty to count 1, possession of marijuana, a felony of the 5th degree with an attached forfeiture specification. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation and report, as well as for a drug and alcohol evaluation. Those reports have been completed. The state has had an opportunity to review those reports, and the state is ready to proceed with sentencing, and the state would move to dismiss the remaining counts of the indictment at this time. Thank you. I apologize. And there are 29 days of jail time credit.
Thank you. Smokey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
I do, Your Honor, and also his mother, Delisa Harris, is here and would like to address the court when appropriate, and I believe my client would also like to do so as well.
Well, we could hear from his mother at this time. Ma'am, wherever you are, you can stand right where it is that you're seated. State your full name and spell your last name for the court reporter, please, and then say whatever you'd like me to know.
Delisa Harris, Harris.
Can you spell the first name?
Yeah, I'm about to spell it Delleesa.
Thank you.
I'm here today to support Joshua, as we know. Truthfully, I've never been separated from any of my kids. There's been some things I've been going through health-wise. I may not look like it, but very unhealthy, which he comes into play to help do a lot of stuff with his siblings, and I grocery shopping, paying bills for me, running errands whenever I'm not able to be mobile because I have spinal issues that keeps me from walking a lot of times. I just want to say we don't have his father. His father passed away in 2021, so he's been kind of the guideline for his 4 brothers that he has at home. And without that, it's kind of putting me in a tight spot. I know he shouldn't be here, and I know he did some things that he shouldn't have done, but he's not a bad person. His character is not bad. He's a very well-rounded young man, and somebody I know who will go far, who's willing to actually work a job. And I'm just asking that he be able to come home because I need him. You may fault him for his wrongdoing, yes, but I do need him. We need him. And I do whatever it takes to keep him from coming back here. I don't raise him like that. I know they all make mistakes, but they got one mistake with me. And this the first and the last. That's all I'm gonna say, thank you.
Thank you. Smokey?
Thank you, Your Honor. Your Honor, he is 20 years old. He has his whole life ahead of him. He's not off to a very good start with the judicial system, but he'd like to, I think, put himself in a better light, steer the ship on a straight course, lead a law-abiding life. As you heard from his mother, he wants to help take care of his family. He was working at Amazon. He'd like to try to get that job back when available, or if not, find a suitable alternative. It looks like there is some marijuana use here. He may need some counseling for that. I think he understands that. Now, he started at a young age, and this is a marijuana-related charge. It hasn't progressed to any heavier drugs, such as meth or cocaine or anything like that. So I think this is a wake-up call to Josh to turn things around, and he'd like to give the court an opportunity to show that he can do that on probation. I know he does live in Cleveland with his mother and his siblings. He'd like to see in the future at some point, if possible, about transferring his probation to Cleveland. But he knows he needs to...
Why would I do that? You committed the crime in Lake County.
It's certainly up to the court. It would just make he doesn't have a valid license, so it might be a little bit more difficult for him to get here. So just wanted to bring that to the court for the court's consideration. Certainly, of course, defer to the court on where he has to be supervised, Your Honor. But I just wanted to mention that might make things a little bit easier to get to and from his probation appointments.
Make probation easier, that's why he wants to do it, but go ahead. Have I ever done that? I mean,
transfer supervision?
To Cuyahoga County?
Well, not very often, Judge.
Not. Just stop right there.
Not.
Go ahead.
Thank you, Judge. He absolutely knows, and if it wasn't in any way clear to him before, to not use marijuana, not be associated with marijuana, not be around marijuana, or if there are any friends or family who are doing it, to not have it in his vehicle, be traveling with them, or be anywhere near it, Your Honor. And again, at 20, I think while he's still developing his life and coping skills, this is certainly a wake-up call. I'm sure he's going to bear the wrath of his mother regarding this, and the one chance that she gives him. So I'd ask the court to take all of that into consideration when imposing sentence today. We'd be asking the court for community control. He does have 29 days of credit. We'd ask for no additional jail to be imposed at this time, and I believe my client would like to address the court as well. Thank you, Your Honor.
Mr. Smith, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Could I stand up?
You can do whatever you like.
Cool beans. Well, I just want to say how you doing today.
Anything you want to say?
To be honest, sitting inside of the jail, for these last 29 days kind of, brought me to the conclusion that that's not something that I would want to do again. You know what I'm saying? And it also, initially brought me a little closer to God. And I've been doing a lot of praying lately, and I got a lot of faith in, the understanding of what's going on. And I feel like if you was to allow me to go home today, they would 100% would never ever see my face again. I set a goal in mind, and I came to the conclusion that I want to make $100,000 this year. And me being locked up inside of a cell, or just dealing with having a law on my back, wouldn't be able to help me make that $100,000.
How you plan on making $100,000?
Well, I'm a brick mason, sir.
Huh?
I'm a brick mason, sir.
Okay.
And I plan on starting a business with doing the bricklaying. And then I also have another business where I can go door to door and sell, insurance and, home security and other things of the sort. So I just plan on getting my life together and working towards making that $100,000. I want to balance myself.
What do you do for Amazon?
I work inside of the fulfillment center. I just pack up people packages and send them out.
Is there anything else you'd like to say?
Well, I'm 20. I turned 21, and couple months. You know what I'm saying? That opens a lot of opportunities for me. You know what I'm saying? A lot of things that I wasn't able to do beforehand or wasn't able to be beforehand, I will be allowed to do this year, and I just ask that with that in mind, just allow me to go home so I can, get my life together and fix what I gotta fix.
Thank you.
No problem.
Smokey, anything else?
Not at all, Your Honor. Thank you.
Mr. Maloney?
Thank you, Your Honor. Based on the facts and circumstances of the case, the state does recommend the court impose a sentence of community control sanctions with local jail time and treatment. Thank you.
Thank you. Court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation, considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today by Mr. Mulkey, the defendant, his mother, prosecutor, the recommendations. I received some correspondence as well. I received a letter from the defendant previously as well as from his mother. I've read those and considered those.
Nice.
All this is considered in light of purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. So the factors in 29-29-12, factors indicating the conduct is more or less serious. The court does note other relevant factors indicating it's more serious as the sheer volume of the marijuana involved. We're talking almost 2 pounds of marijuana that was found, which is much more than we normally see in these types of cases. Nothing makes the conduct less serious. As for recidivism factors, there's a prior conviction on the defendant's record for the attempted carrying a concealed weapon out of the Stowe Municipal Court, which occurred just a couple months before this happened. The conviction itself, the offense was probably a year before that, but conviction was a couple months before. Defendant has a drug abuse problem that relates to the offense, and he denies it. He doesn't want any treatment, doesn't believe he needs any treatment. He's been smoking marijuana daily for at least the last almost 3 years.
Can I speak on that?
Sure.
The reason why I say that I feel as if I don't need treatment is because in all reality, before I even got caught up with any of this, I was in the process to stop smoking anyway. Smoking, I don't believe.
The process is. I'll let you finish first. Go ahead.
I don't believe that weed is a drug that I would need any type of treatment for. If I got enough mental stability to tell myself to stop smoking, and I could stop smoking. Just as well as I told you last time I was in court when you said I wasn't supposed to be smoking on bond, and I told you I would 100% stop smoking.
And you didn't. You kept using it.
No.
Your levels went up when you went back to the probation department the next time. Yes, they did. Don't tell me they didn't.
No.
Your levels went up from when you were here the last time, and I told you what was going to happen if you continued smoking. You went back there, and your levels were higher than they were the first time.
Okay, you say so, sir. You put a warrant out for my arrest 3 days after I told you that the weed was going to be inside of my business in general. You know what I'm saying? So I mean, I don't really understand that, but
I put a warrant out for you. You weren't arrested 3 days later.
But again, though, like I was
a warrant doesn't do anything.
Can I finish talking, please?
No.
Excuse me?
Can I finish talking, please?
Relax.
No, you've had enough. I let you talk earlier. You had a chance to speak. It's my turn now. And you better stop that grinning.
I can't.
You come in here with a smile on your face, acting like we're buddy-buddy. That's not the case.
Okay, sir.
Boy, I don't think probation is going to work here. I was planning on giving him probation, but it doesn't look like that's going to work. Defendant's been smoking marijuana daily since he's been 18. Legally not even old enough to drink a beer, and you're smoking marijuana daily since you've been 18. Doesn't believe he has any problem with that. It's a condition of his bond that he not smoke marijuana, but he smoked it anyway when he was here the last time. Says he didn't know he wasn't allowed to. There was a bond condition form he signed. So that's the same thing he said about the marijuana in the car. He didn't know the marijuana was in the car, yet there's 2 pounds of marijuana in the car. It's not like there's a little joint there. It's 2 pounds of marijuana in the car that he'd been driving. He just kept forgetting to take it out and didn't know it was there. And then when he was here last time, he was told you can't smoke. And his levels went up. Now apparently he thinks I'm just making that up. No genuine remorse. Doesn't believe he should have been charged with this. Doesn't believe he should have been pulled over. Are you going to keep talking? I've given you 2 chances to speak.
I'm talking to myself, sir.
Well, be quiet.
Okay, sir.
Factors indicate recidivism is less likely. There are no juvenile delinquency adjudications. In order for me to put you on probation, or we call community control sanctions, I need to make a finding that you're amenable to community control sanctions, and that's where I'm really struggling. That you're going to follow rules, do what you're supposed to do, follow the conditions that are set by the court. Why don't you have a driver's license?
Say that again?
Why don't you have a driver's license?
Because I got to pay some court fees in order to...
Oh, that's right. There's a warrant out for you, isn't there? You didn't show up. Warrant out of Shaker Municipal Court and Bedford Municipal Court. And show up for court on October 7th of this year.
Yeah,
for driving under suspension.
I didn't even know I had court.
You didn't know you had court?
No, I didn't, sir.
There's a lot of lack of knowledge on your part with a lot of things here. Didn't know there was marijuana, didn't know I couldn't smoke marijuana, didn't know I had court. Well, I will give you 1 chance, Mr. Smith. And find you're amenable to a community control sanction. If you test positive for marijuana, you're going to prison. So don't think of this as, oh, it's just some minor misdemeanor or whatever the case may be. You're going to prison if you smoke marijuana. You say you don't, you can stop it. You say you have the mental ability to do that. We'll find out. I hope you're right. I'd love for you to prove me wrong. I'll put you on community control sanctions for a period of 2 years. Or I'm not going to send you out without any treatment. I'm going to order that you serve 89 days in jail. You have credit for 29 days you've served. I'm going to order that you enter and successfully complete the jail treatment program, get the treatment that they offer there, successfully complete that program, follow their aftercare recommendations. After that, conditions of your bond, you're not to use any drugs or alcohol. That includes no marijuana use. You're to submit random urine screens. They have to be negative. Positive screen's a violation. You can't tamper with the urine sample, bring in fake urine, bring in someone else's urine, nothing like that. You're going to prison if you do that. To attend 2 AA meetings a week and have a sponsor. Obtain and maintain full-time employment. Immediately clear up these warrants when you get out. You can't be on probation having warrants out for you. And just so we're clear, so you can't say you don't know, there's one in Shaker Heights and one in Bedford Municipal Court. Shaker Heights Municipal Court, Bedford Municipal Court. Warrants in each of those communities. Once you get your driver's license back, pay your court costs and supervision fees. I also want you to do a mental health evaluation and follow whatever recommendations are for any type of counseling or treatment that could help you with issues that you may have, that you talked about and that you went through when you were younger. Whatever recommendations are made in that regard. Derek, anything else I should be thinking about here?
No, Your Honor, thank you.
Mr. Smith, you understand the conditions of your probation?
Yes, sir.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, and I'm talking about from this day forward. So if there's issues with the DUS, that happened in the past, clear that up however you want to clear it up. It's not going to, if you wind up being found guilty or pleading guilty, it's not going to impact your probation. I'm talking about conduct from today forward. If anything like that should happen, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I can terminate your probation and send you to prison. And if I sent you to prison, it will be 12 months in prison, which will be consecutive to any other sentence you may be serving at that time or that you may be getting sentenced to at that time. You understand that?
Understood.
All right. Similar, anything else for the record?
Just the balance of the indictment and forfeiture, Your Honor.
Balance of the indictment is dismissed as agreed upon. I'm going to order the forfeiture of the contraband and instrumentalities, and I'll release any bond if their bond was posted. We're not forfeiting bond. Mr. Mulkey, anything else?
No, Your Honor. Thank you.
Okay, real quick, friends. Ohio law, as of December 2023, recreational cannabis is legal. You have to be 21 plus, and that's kind of the thing. But I don't know if you guys caught this. There was a statement made there that he was on bond, and a condition of his bond was that he not use marijuana. And then he got busted with 2 pounds of it in his car. So I think the bigger issue here, we don't have all of the facts because they didn't read out his entire criminal history, that at least that I caught. But it seems like there was some other underlying thing going on, and then he got caught with the marijuana, which he was ordered not to use. And that is whether or not marijuana is legal in your state. We see it all the time where judges will order you not to smoke it while you're out on bond. It's just like how they order no alcohol and things like that. So there was something more going on here than just he smoked marijuana and the court didn't like it. He was ordered not to smoke it and the court didn't like it. Because when we see these things, we always have this debate in the chat as to should we be punishing these things and whatnot. But this was a condition of bond. So that's the bigger issue here. And I wanted to be sure to call that out so everybody was on the same page with that. Let's go back to Judge Glazer. Let's see what's going on there. It's coming up on lunchtime. It should be fun.
Do improper exhibition of a weapon. Say, what do you want, $1 or $1?
$1's fine.
$1 count 2.
Ok, señor, en la primera causa la fianza son $5,000. En la segunda causa la fianza es $1. Para un total de $5,001. Que tenga un buen día. Ya se puede retirar.
And Mr. Trujillo speaks Spanish.
He also has a hold for immigration.
Ok. Señor, usted tiene una retención de migración. Un momento,
Así
por
es.
favor.
Ok.
Hello. He needs a Spanish interpreter, right?
Yes.
Yes.
Yo puedo hablar.
This is
Your Honor, I don't know if you heard me, but he has a hold for immigration.
Thank you. Good morning, Mr. Trujillo. You were arrested for trespass at a posted construction site and resisting an officer without violence.
Ok, señor, buenos días. Usted fue arrestado por ingreso ilegal en una zona de construcción donde había una notificación y por resistirse a un oficial sin violencia.
You also have an immigration hold.
También tiene una retención de migración.
So I'll find probable cause for trespass as well as resisting an officer without violence.
Encuentro motivo fundado para ingreso ilegal, al igual que resistirse a un oficial sin violencia.
I guess there would be probable cause because he acknowledged it, but what do you want? $500 count one and 500 count two. You're ordered to stay away from 1241 North Miami Avenue in Miami, Florida.
Okay, señor. I'm sorry. What is the bond, Your Honor?
$500 bond count one, $500 count two, and stay away from the arrest location.
Ok, señor, usted tiene una fianza de $500 en la primera causa, $500 en la segunda, y tiene que mantenerse alejado del lugar del incidente, el 1241 North Miami Avenue.
All right. You have that immigration hold too. Have a nice day.
Y también tiene la retención de migración. Que tenga un buen día. Ya se puede retirar.
All right. I see TCF here on Zoom.
Yes, we have Mr. Alexander Brown, number 32.
Thank you, Deha. Good morning, Mr. Alexander Brown on page 9. You were arrested for being younger than 21, purchasing a firearm, resisting an officer without violence, possession of cannabis, under 20 grams, prohibited smoking of cannabis. I will appoint the public defender's office for you. So let me see what this is about. Sir, how long have you lived in Miami for?
A year.
A year? Okay. Are you homeless or you have a place to stay?
I got a place to stay.
You got a place to stay?
Yes.
Where do you live?
In Miami.
What's your address?
North Miami.
Oh, okay. Where'd you come from? Miami?
Yes.
Okay. Let me review this for probable cause.
I ain't really do nothing. They just pat me down and started searching me for weapons.
Yeah, well, don't talk about the facts. Anything you say can be used against you, okay? Your lawyer's here, Ms. Hill is here at TGK. Just don't talk about the facts because anything you say can be used against you. So apparently they don't want you at that business. So you're ordered to stay away at 736 Ocean Drive in Miami, Florida, Miami Beach, Florida. You're not allowed to go to that business and you must stay away from them, sir, okay? And you're hanging out.
All right. Appreciate it.
So he had a gun on him. He's 20. Isn't he allowed to have a gun? See?
Well, he can't have it concealed, and then it looks like it's a separate charge for purchasing a gun when you're under 21. He said he bought it at a pawn shop in West Palm.
All right. So there's probable cause for the charges. What do you want me to set a bond?
Yes, he just did 90 days earlier this year.
All right, count one.
Excuse me?
Count one is $2,500. Count two is $500. Count three, $1. And count four, I'll do $1. You can't smoke marijuana in public. All right, that's, I guess, that's one of the issues too. Have a good day, sir.
I wanted to see if I could reduce my bond and lower it.
State, you have an objection if I reduce the bond a little? I'll set count one at
Yes,
15.
Judge.
The 2,000 one.
I mean, he's got the 90 days from earlier this year. He's got a gun, and I do see some priors.
Well, you're allowed to possess a gun if you're under 21. He admitted to purchasing it. He was honest with them. I'll set his bond. I'll lower it a little. Count one, I'll set it at $1,500. Count two is $500. Three is $1. Four is $1.
But he can't have it concealed, Judge, and he can't have it concealed within a certain period of time from the withholds.
Oh, that's the problem. You may have other charges too, because you got that withhold. You can't carry it concealed. Talk to your lawyer privately, all right? That's it. We're done. Total bond is $2,002.
What's the total bond?
1,000 count, what did it say? 1,500 count one, 500 count two, $1 count three, $1 count four.
Thank you.
Next.
How much it would be altogether?
I don't know what he said. Sir, I didn't hear you.
Like 2,000 altogether, or like 1,000?
Two of the counts are $1 each for the cannabis. The purchasing the firearm being under age 21, I reduced it a little. It's $1,500. And count two, I set that at $500. Okay.
So I gotta pay like
$2,002 bonds. Usually the bondsman take a percentage of that.
Yeah, thank you.
All right. Next, we have Daniel Brilliant, page 8.
He's out on probation.
Hold for F23-15120. Good morning, sir. You were arrested for strong arm robbery. I will appoint the public defender's office for you. There's probable cause for the charge. Also, you're on probation. Hold for F23-15120. You are ordered to stay away from the victim, whose initials are AV. No contact with that victim, either directly, indirectly, in person, in writing. That's the cash lady who worked at Family Dollar. He says you stole the cash register. Cash out of the, you removed $80 from the cash register, so that's the victim. No contact with that victim, either directly, indirectly, in person, in writing. You must stay at least 500 feet away from their home, school, and place of employment, and stay away from the Family Dollar store at 4190 Northwest 2nd Avenue in Miami, Florida. So your bond's $7,500, and you'll see your judge tomorrow. Have a good day.
Your Honor, you said 500?
7,500. You have Luis Pasalo Vega, page 8.
Your Honor, he refused court.
Let me review. He's on probation. Hold for F19-13208.
Your Honor, I have another defendant on the Zoom, Fernandez Miguel.
Will be next.
Michael.
Okie dokie, they've gone a little quiet there. Let's go back to Michigan. Judge Middleton has a new contestant. Let's see what's going on there.
I personally would never do that on the stocking.
I know they generally do, but
no, he posted bond on 4/8. So he had 12 days of jail. What's the matter? All right, we're still live. We're still on the record, and we're ready to address the matter of People versus Stephen Ray Kaufman. File number is 251634FY. Mr. Kaufman is here with his attorney, Ross Truckee. Also present is Angelique Camfield from the prosecutor's office, and Nicole Hagaboo, formerly Nicole Sigler, is also present. She's here with us by Zoom. Mr. Kaufman, I appreciate your keeping us apprised on what your traffic difficulties were, and I appreciate you getting here on time in a snowstorm.
Barely.
Yes, well, you're here, and that means you take the matter seriously. You were charged with aggravated stalking, which is a felony, and you entered a plea to a misdemeanor charge of stalking. That plea was entered on December 2nd. I set the matter for sentencing for today. I wanted to get more information about the matter and make sure that Ms. Sigler had an opportunity to be heard on this. And so here we are. So I'll start with you, Mr. Truckee. What would you like me to know?
thank you, Your Honor. Around March of 2025, the wheels fell off for Mr. Kaufman. He found himself facing a divorce, a change of scenery, cleaving a part of a relationship that he'd been invested in, and he did not handle it in the way that society expects or requires for adults to handle those situations. He had a very hard time kind of accepting his former partner's change in position, and he acted out. He was harassing, and well, he pled to this charge. He pled to the stalking charge. He repeatedly contacted her. A PPO was issued. There were violations of the PPO. Mr. Kaufman did not comport himself well during this time, and it's my belief that he's rather humiliated by this and the way he acted when he was in that situation. The saving grace, if we can call it that, is that at some point he was arrested at the end of March, lodged, and got the brakes slammed and got shook up a little bit. He ended up on felony probation that he's been compliant with. It's my understanding that there's been no further conduct since the end of March of this year. So that little bit of intervention by the state's power was able to kind of shake him out of his negative situation and his obsessive behavior and allow him to try to regroup. So here he is trying to regroup. He's made his court appearances. He entered a plea in this again. He's done some jail time between this case and a resisting case and a larceny case, all of which really did kind of orbit around this divorce. I would ask that the court consider time served and fines and costs. I don't know if the court would want to duplicate a probation period because he is on felony.
I do have a concern about that, doing 2 probations. But we'll see. I do have a question, Mr. Kaufman. At some point, you were in the LaGrange County Jail back last February. You got served with this PPO while you were in jail on LaGrange. What were you in jail in LaGrange County for?
I got pulled over for illegal tags. My tags were expired. And I got caught with meth, and I had some guns with me.
Are you done with everything in Indiana?
No, I'm supposed to go to court next month for that.
So that hasn't yet been resolved?
No.
Have you pled?
They offered me a plea deal that I was gonna accept. We just haven't it got postponed until January.
All right, so you're going to LaGrange County in January?
Yes.
All right.
I don't remember the date offhand, but it's coming up. I know that.
Okay. All right, Ms. Campfield, what's your thought here?
Well, Your Honor, I know that the victim does wish to speak to the court, as the court's already indicated, but this is an instance, even though it was reduced to a misdemeanor stalking, the communications and contacts were in violation of a personal protection order that was obtained. She did fear the defendant. She still fears the defendant. There were, by my information, over 31 separate contacts made that violated the protection order, texts, phone calls, driving by the house. And I know she feels that she and her children are not safe because of the defendant's stalking behavior. And it got to the extent that he even cut the Wi-Fi line to the house so that the cameras, the security cameras that were on the yard and driveway and whatnot were not operative, so that he could come to the home unaware for the residents. That is very concerning behavior. I don't think that he is safe, and I don't think that it warrants just a fines and costs as the defense has requested. I would like to see frankly, the maximum jail on this, and then he can go to LaGrange and deal with the potential felony offenses there.
So you're asking for a 1-year sentence?
Well, Your Honor, I guess I would be willing to do less than the 1 year.
Well, let me ask this.
Maybe
If
6 months, because of the continued nature of the contacts and the length of time over which it occurred. And these things were not just observed by the victim and people that she knew. There was an officer present that observed this behavior as well.
And he made the arrest then in August. But if it was that urgent, why did they go from March 27th to August 4th before they even authorized it? And then another 3 months before they served the warrant?
Your Honor, I'd also like to place an objection regarding the cutting the Wi-Fi. There's not been a finding that defendant engaged in that conduct.
All right, well, those were allegations, I guess.
Well,
I know we didn't have I don't think we had a PPO violation hearing. I was always troubled by the delay between the conduct and the charge, and between the charge and the arrest. Because as far as I could tell, nothing has happened since March of 2025, or at least early April. The defendant bonded out of circuit court on April 8th. And then this didn't get authorized until August 4th. So we have April, May, June, July, 4.5 months where apparently nothing happens, and they get the warrant and it doesn't get served, and he's on probation. It should have been very easy to find. The R&O charge was dismissed, and he pled to uttering a publishing case. He's on felony probation, and now the prosecutor asked me to give you a year in jail, and I'm trying to reconcile all of that.
Well, Your Honor, I don't know the reason for the delays, and there was further investigation requested for body cam and digital evidence, in addition to probably the number of communications having to be put together in order for this to rise to a level of a stalking offense being requested. But I don't think the delay negates the defendant's prior conduct, nor do I think that the delay negates the fact that since he hasn't done anything since April or May, that he should just get fines and costs for this. This is an instance in which he was repetitively violating a court's order and placing this victim in fear. yes, I'm grateful that he hasn't done it since he was put in jail for some of it. However, I think that he should receive more jail, not only as a punishment for the behavior that did place this victim in fear, but as a deterrent to others that we've seen in this community that do keep repetitively violating this court's protection orders. Not only bond conditions, but personal protection orders.
Well, they never, as far as I can tell, had a hearing regarding violation of the PPO.
Mr. Kaufman does report he was held on a PPO violation, but I'm unsure of how that resolved.
I got 3 days served for it.
All right. I don't know.
I mean, I guess if he's not going to be on supervision here, and he's most likely going to be on supervision in circuit court for a little bit longer or in LaGrange County, and this court's not doing a probation with respect to this particular behavior, that is all the basis for my recommendation of a pretty lengthy jail term.
Well, one problem, if I put him in our jail, he can't go to his hearing in LaGrange in January, which is probably going to result in a jail or prison sentence in Indiana. If I put him in jail here, it's going to delay his court appearance in the state of Indiana. And that is causes issues. Well, Ms. Sigler, Ms. Hagabo, you've been here listening to all this. I appreciate your being here. I'm glad you didn't have to drive here in a blizzard. What would you like me to know?
Well, I wrote the letter to you. And then I've previously filled out the victim's rights form. I just want this resolved, and I want him to stay away from me and my family. I don't know if he's, I know he hasn't texted or called, and I don't know if he hasn't drove by the house. We didn't know what he was driving until the last court date, but I just want him to leave us alone. And I want him to get something out of it, because he had said several times that he didn't care what the court said or the cop said. He was going to do what he wants. And even Ali answered the phone several times when he called, and he disregarded what Ali was telling him. And he disregarded what Bill Burgoyne was telling him also.
Well, in your letter, does everybody have her letter of December 3rd?
I do.
Yes.
All right. I was going to ask him about this. There's a pink elephant in the room, which is methamphetamine. And people do crazy stuff on methamphetamine. Now, you two weren't actually married, were you?
Yes.
Okay. And at what point were you divorced?
I think it was April.
All right. So I guess I knew that. And as you noted, I did your most recent wedding here at the courthouse. So you were still married at the time this was going on. And subsequent to that, in April of 25, you got divorced.
Right.
All right. Has he contacted you at all since the divorce?
When I filed divorce, it was in March. And when we were in the divorce phase, and that he was still in jail. So the whole divorce proceedings happened while he was in jail.
And where were you divorced?
In St. Joseph County.
All right. Okay. So then once he got out of jail, you were divorced?
Right. I believe.
All right. Yes. And have you had any contact with him since you were divorced?
No.
Okay. All right. And basically, you've got a new marriage. You want to just go on with your life and have him stay away from you and your family. Is that correct?
Right.
And you and he do not have any children together. That's also correct?
Correct.
All right. And the things that Ms. Canfield spoke to in her statements come directly from the victim impact statement and that letter of December 3rd about all the travail that they went through as a result of this. All right, having said all that, Mr. Kaufman, I was going to ask you about methamphetamine. You're on probation right now to the circuit court. The resisting and obstructing charge ended up getting dismissed, and you're on a uttering and publishing charge, which is kind of a strange, not related to any of this. Are you on testing conditions with your probation agent?
Yes.
So when did you last do a drug or alcohol test?
It was the last time I reported.
All right, so
I don't remember the date. It was this month.
Things got better when you stopped doing meth?
Oh, yes. Yes.
All right. Ms. Singler, I don't know if I cut you off. You did share your letter, which was well written. You had your victim impact statement, which I also read. And so this conduct happened in March. He went to jail. You got divorced. He never had any further contact after the divorce. The warrant issued in August, as Ms. Camfield stated, sometimes it takes a while to get all the information together. Then it didn't get served until 3 months after that in November. So between March 27th and the time he actually got arrested, there had not been any more misconduct. He posted bond on the attempted R&O, I think on April 8th. No, on the uttering and publishing. It looked like the other case, the attempted R&O, he didn't get out till it was dismissed on the 20th, on a subsequent date. So it looked to me like he had 12 days plus 17 days for 29 days jail so far in this case. I think I have a plan here, but Mr. Kaufman, I didn't let you finish either. What would you like to tell me?
Just that, you know, I've lost everything since I've done all that. I haven't denied anything I've done. And like her, I want to move on too. You know, I haven't went around her or the house. I haven't drove by the house. I haven't contacted her. I'm ready for this to be behind me. So I'm not proud of it. I apologize to her. I apologize to everybody here for having to go through this too. I'm just ready for it to be over with. I gotta go through the range stuff now.
Yes. Well, I don't want to put you in jail and have you miss your LaGrange County dates coming after the first of the year. So I'm going to do a 6-month probation. I'm going to order 90 days jail, credit 29, leaving 61 days to serve. Of the 90 days ordered, 61 are deferred. So you're not going to jail. I'm going to do a probation, double probation, but the only condition is, well, there's a couple, no drugs and no alcohol. Report for all LaGrange County requirements. Proceedings, we'll call them. no drugs, no alcohol, no contact with Nicole Huggaboo. No contact. The fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee. That's $375. Excuse me, $275. I'm not gonna put you on a probation oversight fee because you're already paying a probation oversight fee to circuit court. And you're right, you owned it. You didn't deny it. It was bad. Miss Canfield's right, and Miss Huggins right. It was bad. You're out of probation here in St. Joseph County on a circuit court matter. Your drug testing, there's probably a condition you not have any contact in that case. So there's no sense doing all that here. But I'm going to do a provision that you not have any contact with her. You report for all of your LaGrange County proceedings. If you end up being sentenced to a jail term or worse in LaGrange County, I can discharge this probation. But I want something hanging over your head until that's completed. So my probation department's go, well, what am I supposed to do? But I'm also say comply with circuit court probation. That $275 is going to be due by March 1st. This is a 6-month probation, which theoretically could be terminated at the end of 3 months. I just want to control over it until your LaGrange County matters are resolved. To your credit, you haven't done anything since you got out of jail in April. To violate either the PPO or any bond conditions. As Ms. Canfield said, that doesn't erase everything that happened before, but it's a good start. All right, if you do what I ask you to do, you're not going to do any more jail time. You take that downstairs to the probation department. And what I hope to hear about this is nothing. I hope you go resolve your LaGrange County matters. We don't have any further issues. Ms. Huggaboo, if there is any contact or any perceived violation of this, you contact the victim advocate at the prosecutor's office or contact our probation department immediately and somebody will take action. What I'm hoping is that it'll continue to go as it has. He goes on with his life and you go on with yours. All right. Anything else you wish to ask or state? All right.
So the people do have a question.
Yes.
We've now been made aware that during his bond for a stalking charge, he was arrested with the potential of possession of weapons and drugs. Just curious if that would be a potential violation of probation if he's convicted.
I don't know.
It preceded that. That happened in February. He wasn't. He was served with a PPO while he was in jail in LaGrange County.
Okay.
So it preceded all of this.
Thank you.
All right. Thank you. Ms. Huggaboo, thank you. Best to you. You're good to go. And
Thank you.
this record's completed.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right, go downstairs to probation and they'll tell you what to do next, and good luck going out in the blizzard.
It's the Courtroom Files Live. It is Monday. Good morning to all of you once again. I've got eyes on a few different places. Again, it's a quieter Monday, quieter than I would expect it to be. I mean, yeah, it's a holiday week, but I figured that a lot of these courts would be getting stuff out of the way. And not as many running today as I expected. I've got eyes on a hearing in the Tyler Robinson situation in Utah. It's a little technical, and I really don't want to go there, but it sounds like the judge is considering redacting some of the stuff from the record that's been put out there so far. It's very confusing, but I'll keep an eye on that. But let's go to Judge Simpson. He has spent most of his morning streaming a black screen and has finally showed up on the bench. So let's see what's going on.
Office for the people. John Shea, Your Honor, with and on behalf of Lisa Keebler.
Lisa Keebler. Morning, Your Honor. I think it's still.
Okay. Go ahead, Ms. Blair.
Teresa Blair on behalf of probation, Your Honor. Ms. Keebler is before the court today for a violation of probation hearing. Ms. Keebler had a new arrest for an OWI, date of offense of December 5th, 2025. There is alleged use of alcohol on that date. I did not know the DEC when I provided that documentation to the court for this hearing, but learned of it this morning. That blood alcohol level was 0.17. So the court is aware that Keebler was placed on a CREMO tether as a condition of her probation that was placed on her on December 11th, 2025. She's had no violations on that CREMO tether since. Given that the case is still pending, probation is recommending that the CREMO tether continue, that Ms. Keebler not go into any places that serve alcohol, that she have an interlock placed on her vehicle through Nationwide, that being today, that she report there directly after this hearing, and that the violation hearing continue or be adjourned to January 28, 2026 at 12 p.m. awaiting the new case being filed. And Your Honor, for the record, I did review that new case, and I can confirm as of this morning, I completed the charging documents and the necessary warrant packet information.
Face forward.
Oh,
You're good.
okay.
Just step back.
Okay.
She's okay.
To charge an OWI third offense. It is an OWI third offense. I see that the defendant's priors are from 2014 and from 2025. So in that case, I have requested $25,000 cash or surety bond for that arraignment. It's a separate issue. In this case, because the defendant was on probation for an OWI related case and then picked up another one with a single vehicle crash into a ditch, people are requesting that she be remanded.
And as to the violation at this point, you're going to admit to that violation, is that correct?
Yes, Ms. Keebler is going to admit that she used alcohol on December 5th, and she will admit that she was arrested as well on December 5th. She is not making any admissions regarding how much she had to drink or anything like that, given the fact that we have a pending felony matter that's charged arising out of the same incident. But she doesn't have a problem acknowledging that she used alcohol that day.
Is that correct, Ms. Keebler?
That's correct, Your Honor.
All right. And the court will accept that admission. So that the record is very clear and that the crux or the majority of the in-chambers conference held with counsel and probation was revolving around, without getting into too much detail, certain cognitive issues and certain other medical issues regarding this defendant. And the court was significantly weighing and balancing a remand as opposed to some other type of process that could, or something that could be put into place, which both, well, fundamentally would stop the defendant's consumption of alcohol, but at the same time, which is paramount to the court, that ensure as best the court can the public safety. And I felt after having heard from everyone that the court's normal practice, which particularly this time of year might be a remand, that the court felt that given all of those circumstances, that another process could be put into place. That doesn't mean at a later date I might not decide that a remand might be appropriate. But at this particular moment, looking to do something a little bit different that more fits with this particular defendant. Paramount in that, and one of the things, and it was stressed by probation and also counsel for the defendant, was the fact that when there is stringent monitoring of the defendant does very well, and there is not the consumption of alcohol. It's when there is sort of a gap there that the alcohol happens. And so two primary issues for the court are the consumption of alcohol and then the operation of a motor vehicle. And when those two come together, that becomes even more of a problem. So I think we fashioned something that will address that, at least temporarily, for the time being. So what I'm going to do and what I'm going to order is I'll continue the scram tether. I will order no driving or operation of motor vehicle without an ignition interlock. I'm going to order that ignition interlock be placed on that vehicle today. You are not to drive any other vehicle that is not equipped with an alcohol ignition interlock. Do you understand that?
I do.
I will adjourn or set for a review, I guess, or continuation of the BOP hearing to January 28, 2026 at 12 p.m. I'm also going to order that you are not to enter any establishment that either sells or serves any type of alcohol. And I realize that that may preclude the entry into grocery stores and other places like that, but that is going to be the order of the court. You cannot go in. If grocery items and other things need to be ordered, they can be ordered. I would not find a violation if you are in the parking lot picking up and there is a pickup of something along those lines. However, you are not to be in those establishments. Is that understood?
I understand.
Is there anything else? Mr. Shea, anything else?
I'm just taking notes, Judge. No, nothing else. Thank you very much.
All right. Thank you. All right. Good luck to you.
Thank you, Judge.
They're waiting you down at AAA for the install.
Yes.
You know where those are?
I'll give them the address. We'll
keep going down Michigan Avenue. You'll see a yellow sign that says AAA. You'll see it. Yeah. Okay.
Okay.
All right. Thank you.
All right.
Thank you, Judge.
Thank you.
I'll get the orders.
Good. Very good. When is she?
Court then is.
And that's the end of Judge Simpson, it looks like, for the day. So, judging from the chat and judging from the current stats, there's a bunch of new faces out there this morning. So welcome to everybody who is possibly here for the first time. It's good to have you here. Join the chat if you haven't already. This is incredibly engaging and friendly community, so be sure to check that out. Subscribe to the channel if you haven't already. Consider joining us on Discord. That is in the pinned chat. Discord's important so you get notifications when we go live and when we post, because you cannot count on YouTube for that anymore, unfortunately, because they're just not doing their jobs like they used to. So that's why we got that set up. Let's go back to Ohio. Looks like Judge Collada has a new contestant.
Robinson, case number 25CR001364. Defendant is present at open court today with his counsel, William Watson. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on November 17th of 2025 when he pled guilty by way of information to count 1, telecommunications harassment, a felony of the 5th degree with a forfeiture specification, and count 2, menacing by stalking, a misdemeanor of the 1st degree. At that time, a pre-sentence report, psychological evaluation, and victim impact statement were ordered. The state's understanding that those were completed and provided to the court, and that all parties are prepared to go to sentencing at this time. Thank you.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I know this court's aware that Mr. Robinson does have a history with violations of protection orders. Prior ones were reduced from felonies to misdemeanors. This particular case, Your Honor, I mean, he did accept responsibility early on. He did take a plea by information. My client has just informed me. So previously, and I believe I put this in a prior motion I filed with the court, he was employed at Lincoln Electric, which my understanding is a very good company. However, he's just informed me, he brought to court today a letter, an offer letter for a dream job in sales. I'll let my client elaborate on that. I was prepared to ask this court for go a certain direction this morning. I know at the last minute I was informed that there may have been some violations with this same victim that's on this underlying case. I would just ask the court at the moment, their allegations, I know he's got a history of this, Your Honor. He did take responsibility in this case. He does not technically have a prior felony record besides this case now. I'm going to respectfully ask the court to take those factors into consideration. My client will like to say a few words. I know the court will allow him to speak, and I mean, he does looks like he has a good opportunity at a job coming up. I'm going to ask the court to take all those factors into consideration. Thank you, Your Honor.
I stand up. Mr. Robinson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, sir. I know that this doesn't look good. I made a mistake. Mistakes. I love hard, and I think there are some definite psychological issues, but I'm working on myself right now. I just got hired at Home Genius Exteriors to do traveling sales. Since I did my pre-sentence report, I've got my driver's license and a job. So a lot of my issues is with free time, and I'm filling those gaps. I have a 5-year-old son and a 13-year-old daughter. I got my dad over there. I have a great support system. My grandpa's 92 years old. My dad's over there. They support me very much, and I just want an opportunity to. I want to prove the court wrong, and I want to prove all my past with this wrong. I know I can do it, and I want the opportunity to. I just want to start my life over and move forward.
All right, thank you.
Thank you, sir.
Mr. Watson, anything else?
No, Your Honor.
Cuts for the state of Ohio.
Thank you, Your Honor. Your Honor, this case encompasses an extended period of time from May through September of 2025. That's for the menacing by stalking, and the telecommunications harassment is August and part of September until the defendant was arrested. In that time frame, defendant was calling Ms. Knapp an amazing amount of times, as well as texting, showing up at her work, at her home, delivering things. We often hear about telecommunications harassment, dozens of calls a day. This is hundreds to over 1,000 for some days. There were 3 different texting formats, a regular texting of your phone, as well as through TextNow and WhatsApp. There was one of them in less than a 24-hour period, 365 calls through that. In a 4 or 5 day period, 106 text messages through regular texts on the phone. Others had 95 in a week-long period. That's just the texting. The phone calls, there was one day that had 1,200 calls. Other days that had over 1,000 or 700 or 900, to the point that Ms. Knapp's voicemail would be full because she didn't answer the calls. She was concerned to answer any phone numbers because she blocked over 40 numbers, because once she would block one number, he would get a different number or use somebody else's number. She felt like she couldn't relax if he would come to her house. There were multiple times he was reported on her Blink camera coming to her house, knocking on the door. She was working on getting a job, so she was missing calls for jobs because she was afraid to answer it, not knowing who it was, and they couldn't leave a voicemail for her. She made multiple reports to Lake County Sheriff's Office before she ever got the protection order. Most of the time, they would call and tell him to stop. She did get a protection order right before she went to the police in this case. While she was talking with the deputy, the defendant called multiple times. She answered for the deputy. The deputy spoke, told him to stop calling. He indicated he wasn't going to stop calling, and then continued to call while they were still meeting. He's had deliveries to her home and to her work.
Let me stop you. You're denying this?
No.
You're denying a police officer told you to stop, and you said that, and that you weren't gonna, and you continue calling even after?
No, about the delivery, sir. I did deliver pizza to her sons. I did
No,
deliver
I'm not
flowers
talking
to
about that.
her.
I'm talking about the police officer telling you, stop calling, and you telling the police officer, I'm going to keep calling her, and you continue calling her.
No, I didn't.
All right, because you're sitting there shaking your head. But,
No, I'm.
Go ahead, Ms. Cutts.
Sorry.
Thank you, Your Honor. So Ms. Knapp has not been able to relax for a very extended period of time. Obviously, the relationship with the victim facilitated the offense. They've known each other at least 2.5 years. They do have different versions of their relationship. She does not indicate that they had a long-term romantic relationship and that they were friends more than anything else. The phone records have indicated these number of phone calls and text messages, all of that information. He does have a criminal history that includes one juvenile adjudication in 2000 for disorderly conduct, but his adult history also began in 2000. Loud music, 2003, conviction for disorderly conduct, 2005, convictions for drug abuse, as well as a separate case of possessing drug paraphernalia. 2007, he has a drug abuse conviction, as well as an OVI. 2011, he had a possession of drugs that was reduced from a felony to a misdemeanor. He had a probation violation in that case. In 2013, he had another possession of drugs, which was reduced from a felony to a misdemeanor. He had a probation violation in that case. 2013, he also had convictions for assault, a theft conviction that was reduced from a felony, and a contempt of court. In 2016, he had misuse of credit cards that was reduced from a felony, as well as contempt of court. Also had receiving stolen property, some convictions for permit fees or work without permits, contempt of court. 2020, a conviction for failure to control drainage. There may be a warrant out in that case. There's also an assault that was reduced from a domestic violence, where he had a probation violation and a telecommunications harassment. 2021, he has a conviction for violating a protection order and contempt of court. 2023, convictions for assault, menacing, criminal damaging, and resisting arrest. He had a probation violation in that case. In 2023, again, he had a drug abuse, 2 counts, conviction with a probation violation, and in 2024, conviction for escape, a probation violation. He currently has a warrant out for Parma Municipal Court for a 2019 case for failing to appear. When he committed these offenses, he was on probation in Parma for that case. There were some issues when he was in the jail. Appears in September there was threats violation. As I say, there have been some inconsistencies in that the defendant has given versus what the victim has indicated, as well as even in his report. At one point, he said he sees his kids whenever he wants, to who did the psychological, but he told probation that he hadn't seen his son in an extended period of time. So he has not responded favorably to previous sanctions, the probation violations, the convictions, being on probation, and the state just learned this morning of at least a violation of his probation. I believe he has been arrested on a warrant for new charges. Obviously not a conviction at this stage, but the information that was received by the victim advocate directly from the victim, not just what law enforcement was indicating, was that the defendant has been calling her for weeks, showed up at her new work about 3 weeks ago, has been leaving things on her car, and that the biggest issue yesterday, she was leaving her house. When she got to her car, the defendant began screaming at her from a vehicle he was in. When she got into his car, into her own car, the defendant came up to her car and was banging on her windows. Her son came out, who was also under the protection order. The defendant spit on the victim and then ran to his car, and whomever was driving the car, his friend Mark, drove off. So it's my understanding they got a warrant and he was arrested on that today. I've not seen any police reports or anything of that nature, but Ms. Knapp did inform our victim advocate today. She would have been here today, except she is ill, that had happened yesterday. So at a minimum, it's a violation of his probation based on the information she's providing us.
Probation.
Sorry, a violation of his bond. I misspoke, you are correct. At a minimum, he was on probation when he committed this offense. I do believe, the state does believe prison is consistent. When Ms. Knapp came for the information police, she had indicated since he had been arrested, he had been leaving her alone. So we were hopeful and optimistic that that would continue. The fact that he has not done so seems to indicate that he is not going to stop, especially it being the day before coming into court for his felony sentencing. So based on that, we do not believe he is amenable to community control, and we would ask for prison in this case. There is the forfeiture of the cell phone, and that would be the state's recommendation at this time. He has 0 days credit. Any time he served was for another sentence.
Thank you. This court has reviewed the pre-sentence report and investigation, psychological evaluation, consider the facts and circumstances of the offenses involved, the nature of the offenses. I consider what's been said here in court today by his lawyer, Mr. Watson, the defendant himself, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. So the factors in 2912, factors indicating the conduct is more or less serious. The court notes the defendant's relationship with the victim facilitated the offense, and that the victim has suffered serious psychological harm as a result of the defendant's conduct. Other factors indicating it's more serious are the relevant factors. I've been doing this for a long, long time. I've never had a case like this with this much disregard for orders and for the sheer volume of phone calls that were made to this. I don't know how that's even physically possible to make 1,000 calls a day, 600 calls a day, text messages. I assume you sleep a little bit, so that even narrows it down somewhat. I don't know how you do that. The sheer volume of calls and contact that you made to form the basis for this, it's the worst I've ever seen. Nothing makes it less serious. As for factors indicating recidivism is more likely, the defendant committed this offense while he was on probation. There's a history of criminal convictions, and part of the problem is that she had at least 5 cases that have been reduced from felonies to misdemeanors. And I think the defendant's gotten used to that. Not facing consequences for his conduct. He's getting breaks and just expects that. He's clearly not responded favorably to previously imposed sanctions. He's been on probation before. He's violated his probation. Again, he's gotten multiple offenses and reductions. And in terms of not following previously imposed orders, that's the whole nature of the cases here. Prior violation of protection orders, harassment charges. Just in the last 3 charges, violating a protection order, telecommunications harassment, menacing, assault, resisting arrest. It's just a pattern here that the defendant does over and over and over. You made a comment earlier about this being a mistake, and I said mistakes. This isn't a mistake or mistakes. Mistakes are somewhere you don't intend to do it, and it's some accident. These are deliberate actions that you do over and over and over, 1,000 times a day. Those aren't mistakes. You're deliberately disregarding orders. Even the police said stop doing it. You told them, well, I'm not going to stop. I'm going to do it. I don't know why. I can't figure this out. There's no way this court could ever make a finding that you're amenable to community control sanctions, which means that you're going to follow court orders, you're going to follow the rules of probation. You've demonstrated that you're not going to do it. You've vocally said you're not going to do it. There's no way you'll ever comply with conditions of probation. You've told us you're not. No factors indicate recidivism is less likely. There's no genuine remorse also in regards to recidivism factors. Under 2913B1, court finds, again, the defendant was on probation at the time he committed this offense. Prison is consistent with the purposes and principles of sentencing. As I earlier indicated, the defendant's not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 1, the defendant served a term in prison of 11 months. On count 2, he served a term of 180 days. So in the misdemeanor, it must be concurrent. There's no credit because all the time he spent was serving another sentence. Need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 5.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs, and I'll order the forfeiture of the contraband and instrumentalities. Cuts, anything else for the record?
No, thank you, Your Honor.
Bond will be released. Mr. Watts, anything else?
Nothing further, Your Honor.
So yeah, 11 months does not seem like a lot there. Quite honestly, I wonder what the range of punishment there is. If they talked about it, I didn't catch it because in the middle of this hearing, I was monitoring other things, so maybe you guys heard it. But it is definitely on the light side for sure. So again, some new faces out there this morning, so welcome. I do have one requirement if you're going to be with us here, and I just dropped the link in the chat. If you like what you see here, you also need to go to Michael Groff's channel, and you need to follow him because we keep a weatherman on staff here at TCF. Michael is great. He does a weather channel, weather content. It's very good. Even if weather is not your thing, you want to listen to him just for the voice. He's got that perfect radio voice. He does this so much better than I do. Plus, Michael is also the official TCF guest host. So when I can't do this show, he does it. So get to know him. And if you're like most people, you'll probably prefer it when he's hosting as opposed to when I'm doing it. But such is life. Let's go to El Paso, Texas, and we'll probably spend the rest of our morning with the jail magistrate there. That's often a good time. Let's see what's going on. Let's not, because they just deleted their feed. All right. It's a weird day. This one maybe? Hold on. No, that wasn't jail magistrate that I went to. That was a different court. This is El Paso jail magistrate. Okay. It still works. We're good.
With you, okay?
Yes, sir.
How much follow each and every one of these conditions? Because if you decide you go, I don't want to follow him, then I'm going to revoke your bond, bring you back to jail. 1, you will report. Your peer bond officer has instructed. That means you will report when they tell you to report. Now, when you feel like reporting. 2, you cannot be rearrested for any new offenses while this case is pending. Mr. Briggs, what's the address of the church?
Judge, I don't have it here in the affidavit because the officers responded to the location where they found him walking
Okay,
around.
what's the name of the church? Because I know that the church's name is given in the affidavit.
Judge, the church is the Iglesia El Cordero de Dios.
You cannot go within 200 yards of that church, sir. Do you understand?
Yes, sir.
If you go back there and we find out, I'll revoke your bond, bring you back to jail on a much higher bond. Do we understand each other?
Yes, sir.
All right, thank you.
Go grab some go there. Thank you.
And Judge, the last one from this floor, besides Mr. Mena, I have Arzaga Oscar.
Okay, let's get him out here.
Judge, I saw that they brought Mr. Rice up.
Yeah, he's not next. We're going to do him after we finish with this guy because Like, I'm gonna ask this officer that if the interpreter hasn't logged on, go to the next floor, and then we'll figure out what to do with this first defendant, okay?
Okay.
So this is Mr. Arzaga here. He's here on a charge of harassment with a $7,500 bond. Permanent attorney is Leonard Morales, but for purposes of this bond reduction hearing, you are going to be represented by Mr. Hernandez from the Public Defender's Office. He's going to present evidence on your behalf to try and convince me to lower your bond. Then I'm going to hear from the prosecutor, Mr. Briggs, to nominate my decision. Go ahead.
Yes, Your Honor. Edward Hernandez on behalf of Oscar Jesus Arzaga, Your Honor. He is a United States citizen. He's been in El Paso County, resided in El Paso County for over 25 years, including 23 years at his current address on Colina Bella. His verification person is his mother, Mary Arzaga, Your Honor. He did not complete high school, but he is married. He's, and like I said, he's lived here over 25 years, and he has worked here. He is employed doing painting with the Williams Company, Your Honor. He's been doing that for 2 years. He has had 2 federal cases, Your Honor, and previous domestic violence charges, Your Honor. He was born and raised in Arizona, but his family has moved to El Paso County. He has 0 money to put towards a bond, but we'd request a full PR bond at this time, Your Honor.
All right, Mr. Briggs, prior criminal history.
Judge, I see convictions for evading in 92, failure to ID in 94, assault family violence in 2005, failure to ID in 2006, assault family violence enhanced in 2008. May have completed some probation on that. I don't know if that was revoked or not, but he's also got a federal pen trip from the early 90s out of Oklahoma for possession with intent to distribute or deliver, I forget what the D is for marijuana, and then another one in 2001, also with the feds. So I think he is, well, it was a misdemeanor case. I was going to say, it looks like he can be habitualized. Judge, my concern is that the address that he's been living at for the last 20 years on Colina Bella is the address where the harassment was taking place. This is the home also where I believe the ex-wife is living. And
if he gets any type of bond reduction, he's going to have to move out of there. He's not going to go back there. Period.
And the harassment.
Nonetheless, I'm concerned with the facts of this case.
Right, Judge. I was just going to say it was between 12/9 and 12/27. So between the 9th and the 27th of December, he sent the CW 730 text messages.
And then 175 phone calls.
175 phone calls during roughly the same period.
I mean, I'm sure the sheriff's office, the investigating, should have a record of all of them. So we'll shake your hand. All
right. Yeah, I'm sure that those are on her phone. So
and I think your office could very well make this a felony stalking case. I mean, that's based on my reading of that statute. All those cases that I screened over all those years, which I hated with a passion, but that's just, I'm getting editorializing in here. All right.
I agree with you about the stalking thing.
All right. Yeah. So I'm going to put the bond at $4,000 with conditions, because I need to make sure that he gets it through his head that he's not to have any contact of any kind whatsoever with this person. Defendant will report to his supervision officer as instructed. This is going to be under intensive level supervision. 2, defendant cannot be rearrested for any new offenses while this case is pending. He's not allowed to possess or consume illegal drugs or alcohol. He's going to be subject to random urine analysis and personalized. And he's not allowed to have any contact of any kind whatsoever, in person, by phone, social media, et cetera, et cetera. What's the name of the complainant?
Judge, the complainant is Yolanda Rodella.
And he cannot go within 200 yards. Do you have the address in there, Mr. Briggs?
Judge, it appears the address is 1200 Colina Bella Drive.
So you better find somewhere else to stay, sir, if you're going to get out, because if you find out you're going back over there, we'll yank your bond, bring you back on a way, way much higher bond. Thank you.
Judge, you lowered that from
7,500 to 4,000.
4,000 cash or surety, but is there going to be
with conditions?
With conditions. Okay. Yes. Gotcha.
Well, that was 4,000 PR with conditions, Your Honor?
No. It's 4,000 cash or surety with conditions. All right. Let me.
And Your Honor, the rest of them are on another floor. I could come
No,
back.
actually, you know what? Let's do the Spanish speaker because the interpreter just logged on right now.
Okay. Sounds good.
Annex, I'll be with you shortly, okay?
Yes, sir. Thank you.
All right. This is Mr. And Mr. Briggs, on this one, I'll need a brief summary of the facts when it's your turn, okay?
Okay.
So Mr. Mena's here on this is a reset from yesterday. Mr. Cifuentes, could you make sure to see if it's working properly, please? Officer, could you make sure the interpretation mode's on your laptop?
Yes, sir.
Mena, it's Francisco Mena.
Yes. And we can't hear the interpreter, Your Honor.
Okay. Because that already set over here.
And he's not coming through, Your Honor.
They need to put it in English mode, right? Or Spanish mode?
Let's see.
Right?
Yeah, no, nothing yet, Your Honor. We can't hear him.
Okay, let me.
See.
Okay, let me see. Hold on a second. Let me. I don't know. Hold on a second.
Let me try logging out and then logging back in, Your Honor.
Okay, try it again. See. Okay. In the meantime, Annex Court, let's do the class here real quickly. I'll be with this gentleman here in a second too. You guys need to worry about this other matter with the annex, okay?
The class is ready. Okay, perfect.
Okay. You speak English, okay, sir?
Yes.
All right, you're here in front of me because on 2 traffic tickets, okay? From the county, one's for no insurance, the other one's for driving with an expired license. I'm gonna go over briefly over your legal rights, and I'm gonna tell you what your options are, okay? You have the right to plead not guilty, to ask for a trial, either in front of a judge or a jury. At the trial, you have the right to be represented by an attorney, but if you want an attorney for this kind of case, you have to hire your own, because under the law, the most you can get is a fine of $500. You don't get an attorney under those circumstances. At the trial, you have the right to force the state of Texas to prove each and every allegation against you beyond a reasonable doubt. You or your attorney have the right to cross-examine or ask questions of the state's witnesses. You also have the right to bring witnesses in your own defense. If you are found guilty, you can be fined up to $500 per ticket, and you can appeal to the county court. You can also plead guilty in front of me here this morning. If it's your decision, I will set you fines. And probably, unfortunately, you're going to need to stay at least one more day if you plead guilty, because you only have 1 day credit. You will need at least 2 to satisfy. One of the fines is a no insurance, and I cannot give you a very low fine on that one, unfortunately, under the law. So what do you want to do? You want to plead guilty or not guilty?
Not guilty. I want to ask for a trial.
Okay, thank you, sir. That's all. Then post your bond and get out, sir. Thank you.
Thank you, Your Honor. That's all we have.
All right, thanks.
Post your bond and get out, sir. Good advice. All right, I think that's it for today. I need to go spend some time with the birthday girl. Unless, of course, the birthday girl tells me that what she wants for her birthday is to be left alone, in which case I'm going to go hide in my workshop or something for the day. But you let me know, sweetheart, what you want, and that's what we'll do. But we will be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Hopefully there's some good courts to watch. I think we cobbled together a pretty good show today, considering not much was running. I actually wonder in Michigan how much more court was actually scheduled but didn't happen because of weather and stuff that they're having there. But we will see. So, yeah. Again, tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. And then the Wednesday, Thursday, Friday shows this week will be best ofs again until we get back on a regular schedule next week. But go have yourselves a good Monday. I look forward to seeing you all tomorrow. In the meantime, take care. God bless.